So even though I've got this little pie chart, and the pie chart, strictly speaking, has only 4 bits, and next week we're actually going to do some more stuff on contracts, but that's statutory stuff. This, I reckon, is the most important. This is the stuff we're going to talk about today, which is going to be the ending of contracts, which can be the easy way for a contract to end, of course, is that both sides do exactly what they say they're going to do, and they never have to worry about it ever again. But we know that's not how life works. And to be honest, the only reason you really need to know how all this law works is for when things go wrong. That's really what that's about, and that's why we spend a non-zero amount of time going through and talking about it. It's important to know how to end a contract and the consequences of breach, consequences of performance, and other mechanisms we can use for contracts to come to an end. All right, so this is the fourth one of these, and like I said, strictly speaking, we're going to be doing some more next week on the statutory rules, the Australian Consumer Law and the Sale of Goods Act and so on. But in terms of the basic rules of contract, this is the fourth of 4. All right, and we're going to look at, we use the term discharge to just describe the ending of obligations, so discharging an obligation. And again, that can come about through a variety of ways. There's first 6 examples there are examples of discharging obligations under a contract. Through performance, doing what you said you're going to do. And there are some, like a lot of things we do in the subject, there are some extra little rules we've got to take into account. The second one is through breach. And the process when one or both sides breach a contract, we've got to go through and talk about, because some breaches can put a contract to an end, but not all breaches do. Sometimes very small breaches don't cause a contract to finish. Repudiation is a technical legal term to describe the situation where one side, sometimes both sides, but usually just one side, is demonstrating an unwillingness to perform. And it has its own section or its own sort of categories and rules that we have to talk about, because things become a little bit tricky. If you're, particularly if you've got long-standing contracts and you're doing lots of little bits of performance and you reach a certain point and realize that the other side's not doing what they said they're going to do. And again, if we go back to the rules of ye olde England, it's to try and make this efficient. We don't want sides to carry on performing their side of an obligation while the other side's not doing anything. So there are some extra rules that the courts have got there in situations where one or both sides has what we say repudiated, demonstrated an unwillingness to perform. I'll talk about that in more depth. Contractual obligations can actually come to an end in many situations through agreement too. That's actually pretty simple. I don't talk about that too much. If both sides both agree from a certain point in time they don't want to do this contract anymore, then that's usually fine. A doctrine of frustration. Frustration here is again used as a technical term to describe situations where an event has happened after formation that neither side could have thought about, contemplated, that completely undermines the contract. And there's some special rules for what happens next. And finally, contracts can come to an end through the operation of law. Usually statutory mechanisms can cause certain types of contract to come to an end when particular events or points in time occur. All right, so to be honest, the slide's a little bit misleading, because those first 6 things are really examples of ways of discharging obligations, but the bit that we really, really care about as accountants is dollars. And we use, again, this technical term damages, that is describing money payments that are made as a result of contractual breach. We use the term in law damages to describe money used as compensation. But here in contract law, we're thinking usually in terms of compensating the other side for their loss. And the calculations of those damages can be quite interesting for us without putting our accounting hats on. But there's super important rules to know. Super important, because this, I talk about things that may or may not come up in terms of your personal and professional lives. you guys are going to be involved in operations, and again, I kind of think a lot of people in this room will end up being financial controllers. Some of them, already are in their own businesses or in or for third party operations. But you guys are going to be in situations where you're going to have to either be the party in breach, or the other party is going to be in breach, and you've got to work out what to do now. And knowing those rules right now ahead of time are huge. Like I said, I'm really not trying to downplay this when I'm saying this. The rules that you'll pick up today, you should try and tuck away. They are going to be pretty important for your professional life. Because look, let's face it, when we're doing I'm putting my accounting student hat on here, when doing auditing and when doing financial management, cost accounting, usually the situations you're given is a scenario, all right? And this thing comes in and that thing comes in. You've got to work out the costs to value these things using generally accepted accounting principles to come to a result. And that's all fine and good. And sure, when you go out to the field into the real world, things can be a bit more complex than that. You've got to, again, put a lot more thought into doing that. But in things like contract law, the situations that we've got here and situations in the real world are when things have gone wrong. You don't need to know any of these rules. If no one ever breaks a contract with you and you never break a contract with someone else, you don't need to know these at all. But when it does happen, you want to be the one empowered to know what the rules are when you guys get asked, what are we going to do now? What happens next? And I think that's why this is, I personally think, a particularly useful set of rules and principles to know, because even in other jurisdictions, a lot of these sorts of rules apply in a very similar way. So if you guys do go back to the subcontinent, or Kenya, PNG, where have you, you'll find that a lot of the universal principles that the Unicontrol and other legal systems, particularly those influenced by the British common law, will follow very similar rules, and knowing them is huge. Okay, and that point 9 is to do with what we call equitable remedies. These are things where you get, or you want to get something from the court that is not dollars. And you think, why would I ever care for something that's not dollars? Well, in some situations, you actually would rather the other side, rather than breaching and not selling you the land that you've entered into a contract with, we'd actually want them to convey the land to us. The land is more important than dollars. And so there are some situations where you can ask the court to make people do what they said they're going to do. It's pretty narrow. And there are some other times too we can need to get things like injunctions. If there's going to an imminent likelihood that you're going to suffer a massive amount of loss or harm. So I'll talk about those towards the end of the class. Righto. Okay, so we're going to start with point number 1. We know now what a contract is. Come together, had a meeting of minds. We've satisfied all of the elements: an offer, an acceptance, intention, create legal relations, capacity, consideration, mutuality, legality. Cool. So what happens, and again, poor old Jean, same example that I use in pretty much every time I teach contract law, selling me a boat, $10,000. I want the boat, she wants $10,000, we swap, we walk away, and that's the end of it. Okay, what happens if I'm selling her the boat, she's selling me the boat. If Jean walks away and then counts all the notes out and finds that instead of $10,000, there's $9,999.50. 50 cents short. Okay. All right. Strictly speaking, I haven't lived up to my side of the bargain. And strictly speaking, Jean can actually go and bring an action in the courts to recover that 50 cents. So the example that comes from here is Qatar and Powell. Now, this was a situation where a widow was suing. The widow, strictly speaking, it was for the estate of a person who was a shipman going between the Caribbean and Britain. And it was the person got paid a sum of money, or something like 19 pounds, some huge sum of money in the 1700s, for acting as a crewman from Britain to the Caribbean and back again. All right, when you do this whole crap, at the end of it, you're going to get paid £19. What was the trouble? Well, 100 nautical miles out from Portsmouth or wherever the boat was, he'd done the whole thing. It was all the way back, and he said not far from the finish, he died. And so there wasn't a term stipulated in his contract as to what would happen in terms of him dying. And so the widow, got the executive of the state to try and sue the shipping company and say, look, the guy performed almost all of the contract. And the courts actually said no. This was a contract that had to be completed in entirety. It seems a little bit harsh, and it is harsh. So the default rule is, if you don't do what you say you're going to do, strictly speaking, to the letter of the law, the other side can actually bring about an action. And here, in that situation, in Qatar and Powell, that made none of the amount recoverable. So you've got to be a little bit mindful that is the default position. The courts, as we've sort of seen from a variety of other areas that we've looked at, are actually pretty harsh in terms of sides doing what they say they're going to do. But mean the guy dies, but at the end of the day, that's not fundamentally the role of the courts, is not to mitigate that. That is to ensure people do what they say they're going to do. However, there are going to be some situations where a contractual obligation that hasn't strictly been performed, the courts are going to say, this is so minor, we are going to consider it to have been exactly performed. And so that Shipton, Wetton, Anderson and Wheel Brothers case involved a cargo load of wheat. It was something like 11,000 tons. And the people receiving the wheat clearly didn't want the wheat by this stage. By the time it arrived, maybe the price had dropped or something similar. And so they measured it all out, and it turned out that it was 11,000 tons plus 32 pounds extra. Not under, extra. And they literally tried to bring an action saying that under the clearly stipulated terms of the contract that said it had to be perfect. And the court said, go away. This falls under what we call the ladder maxim of de minimis, which is the de minimis non curis lex. The court does not concern itself with trifles. It's an unusually phrased. It kind of sounds like it contradicts the previous one. But fundamentally, that amount of, as I said, something like 30 pounds, relative to the size of the entire cargo, rendered it utterly trivial. All right, and this is contrasted again with Qatar and Powell, which was a contract of personal service, required the person to go the entire length from one end to the other. And the court said no, them not actually attending that last 100 nautical miles did render it not discharged by performance. All right, so those things can be a tricky one to note. And look, at the end of the day, I think it might be helpful to think of the de minimis rule as being akin to us putting ourselves in the position of the court. If you just imagine you're a judge or a magistrate, and you've got all of these cases that are coming in, and somebody comes in because they've bought a cargo load of shoes or something similar, and one pair was faulty. At the end of the day, it doesn't matter relative to the size of the contract itself, and that's the key thing. Whereas me, with my $100 stationery order, the courts are willing, or rather the tribunal in that situation, are willing to go and hear those sorts of matters. And I don't have the exact case citation for it. I found it and I've lost it again, so I have to go and hunt for it. It was actually a case that I came up when I was doing some research on residential tenancy to do with body corporates. Does anyone know what a body corporate is in relation to a building? If you've got large buildings that have multiple dwellings inside them, apartment complexes and townhouses with more than two. In Queensland, you can have some old school ones, but generally things that have been built over the last 40 years will have what's called a body corporate establishment, which is essentially a company. It's a legal entity that can sue and be sued, has sui juris, standing in the eyes of the law, and its sole purpose is to look after that building. And the reason why this came about is that the way the fees were payable one year, it was $2,000, it's a mathematical formula, it came out as $2,700.01, and the woman had posted a check, or paid cash actually, for $2,700. All right? Didn't pay the 1 cent. I'm not making this up. And the question was, could she vote at body corporate meetings? And QCAT actually said no. Even though it was 1 cent, they held in that situation that that person did not get voting rights until that 1 cent had been paid. I actually had a contract. I had a fencing dispute last year, and they sent me an email after we paid, again, the final $2,400 for the fence. And they sent a very, very sweet email saying, it's actually 12 cents more. They actually literally sent us an email and said, can you please send us that 12 cents? Now, who here has worked as a financial controller or a bookkeeper or had to do accounts receivable? Has anybody actually been in that role? Anybody had to do that? Have you been faced with these sort of situations where somebody has paid and they've paid like $1 less? The thing is that we have no power to write that off. That will sit in your accounting system forever and a day, or at least until it gets written off. But it gets written off as a bad debt, which is kind of silly and not really a true reflection of what's happened. And so I did go send the other 12 cents through, and they had to go through and issue an entire separate receipt. All right, but just make note that if that was to go to court, the courts would tell them to go away, or at least the contract would be considered, from my end anyway, to have been discharged by performance. All right, so that's the first rule you got to tuck away in your head. Contracts can be discharged through performance, and that means that your obligations come to an end, even though there's a tiny little bit left. All right, in most situations. Now, the courts, again, are not destroyers of bargains. They don't like people breaching contracts and bringing contracts to an end. And so one of the rules or principles that they've developed and is in situations where a contract can be chopped up into smaller, divisible obligations, the courts will, wherever possible, to try and uphold the bargain, do so. And so an example we have is, say you have a house, you want it to be recarpeted, all right, and there are 5 rooms, and each room is approximately the same size and has the same amount of carpet in it, and the amount is for $5,000. All right, somebody comes in, they do the first 3 rooms fine, they do the 4th room, they do a terrible job, and they don't do the 5th room. What's the court likely to do? They're likely to chop that up into essentially 5 different contractual obligations. The first 3 are done. They've been discharged by performance. The other side did what they said they're going to do. We're only going to analyze the other 2. The one that's been partially done, and one that hasn't been done at all. Because that's pretty obvious that no performances occurred, and that makes the analysis from a contract law perspective pretty easy. Steele and Tardiani involved the purchasing of fence posts, a whole bunch of fence posts. We're going to buy 10,000 fence posts, and we're going to pay $1,000 for those 10,000 fence posts. Oh look, they only delivered us 8,000. What's an appropriate amount to pay? It was 800 or 8,000. I've actually forgotten already. It is just as commonsensical as it sounds. So even though the contract, strictly says 10,000 posts, $10,000, you deliver 9,000 posts or 8,000 posts. All right, the courts are very likely to say this contract is cleanly and clearly divisible. Therefore, we're going to deem this part to all be discharged, done, and the rest of it is the bit that you can fight over. Okay, and again, I'm hoping that for most of us with our accounting brains on, is pretty logical. I mean, jokingly say that judges are definitely not accountants. But sometimes they do actually go and resolve things in quite logical ways. And I think that's an important one to note on the back of your mind. But again, sometimes it's not going to work. Going back to the Qatar and Powell. Oh, well, £16, 16,000 miles. The guy didn't do the last 100 miles, therefore we should only get paid, £15, and I don't know how shillings work. 12.5 shillings? I got no idea what it is back in 250 years ago. But there they said no. I said no, that's not cleanly divisible. You have to do the whole thing. And so you guys are going to have to leave that on the back of your mind. If a contract can be chopped up, courts are willing to do it. But in some situations they can't. Building 3/4 of a bridge is not going to get you 3/4 of the money. Does that make sense as an example? If it's, fundamentally, it's not something that can be divided up. All right. So, going back to my example with the 5 rooms being carpeted. If you've got one room, well, just think about that one room, $1,000 for one room, and they've done most of it, and then they've disappeared. I've called you up and said, oh, I've got no more carpet, sorry. The thing is about contract law, it's really harsh. From the person who's in the contract's perspective, do we care that there's no carpet left? Well, I mean, we care because we're not going to get a house done shortly. But are we sympathetic towards the person that's run out of carpet because they can't find it with their supply? It's not our problem. You have to be a little bit cold in contract law. The fact that the other side may have all sorts of excuses that they give you. Oh, my supplier had a problem with this, and my mum's not very well, and these things. We don't care. The courts don't care. When you enter into a contract, if you are going to have a hard time getting carpet, in this case, from your supplier, right, don't enter into a contract, because the person that you've contracted with to fix their house, they don't care. It's not their problem that your suppliers are having problems. There's actually an area, by the way, I found in times where I've examined this subject, and previous ones that I've taught as well. This comes up a lot, usually from people that haven't turned up to class. I've got to say, that type of situation. Oh, it's not the person's fault that they can't get it from the supplier. Doesn't matter. You have to be a little bit cold about it, because that's fundamentally how the courts work in relation to this. Look, there are other doctrines. We accept we're all human beings. We accept we have human frailties. We accept that there are some situations. And again, the Australian consumer law, we'll go through and we'll talk about some of those things. But strictly speaking, the person who's paid for the work is entitled to what they've paid for. So if this carpet's been put in, it's got some defects, and that person's disappeared, what can you do? What can you do if you've got your house is half carpeted, or even worse, your rental property is half carpeted? You want to go and get tenants in. What can you do at that moment? What's a practical step you could take? I'm alluding to it on slides there as well. If they've said to you, "Oh, I can't get it from our supplier. It's going to, it won't be another 6 months." You say, "Okay, all right. So you can't do the job. I'll get someone else to do it, to finish it." That's okay. If you're in a situation, and again, I'll talk about these rules of repudiation where they've clearly demonstrated that they can't, or either unwilling or unable to perform, all right, or they reckon that they've finished it. No, there's nothing wrong with it. And you're like, yeah, it is. And so these two cases here, this Honing and Isaacs and Bolton and Mahadeva, both involved heating systems in houses, boilers, I think is the technical way of describing it. And in one of them, the work to install this boiler was substantially done, but there were some small defects. The thing needed fixing in some way. It might have been building work. Something needed to be changed. It wasn't big, but it cost a little bit of money to fix it. All right. And there the court said that, look, we're not going to be the destroyer of bargains. This contract was for this much, and you reckon that you finished it, they reckon you haven't. These guys have managed to prove to the court that there were some defects, and they've paid someone to do it. We're going to deduct that amount from the contract price. it's really logical when these things come up. And you guys are going to be, I suggest, in situations as chief financial officers, the people they're going to come to, hey, we've ordered such and such, we haven't paid yet, but there's this defect and that defect in this thing, or they didn't deliver it on time. What do we do? And the first thing to note is that, look, if it's near enough, but it's going to cost a little bit of money to fix or remedy that defect, as long as it's reasonable, pay them the contract amount less what it's going to cost to fix. Again, you have to be able to prove it, but that is one way the courts can actually discharge the obligations of parties through performance if it's small. However, if it's large, that's where things can be problematic. If the amount, and again going back to the carpeted room, single carpeted room, if they've only done half, all right, that's that's not going to discharge your obligations under the contract. So where the guys come in, if they've done 98% of it and you've got to spend a little bit of money, 98% is near enough, is almost good enough. Yes, we can reduce the contract by the amount we have to pay to fix it, but if they come in and they've done 70%, that's just a breach. It's a straight up breach of contract. And we're not under an obligation at this point to accept that. If we're the purchaser, we can, hey look, it's going to cost all of this money to fix it. We can go through and do that. But the usual procedure in that situation is to say, this is a breach, it's a fundamental breach, we're not going to pay. We're not going to pay until you've done what you said you're going to do. All right, it's a fundamental breach. And the side that's only done half the job, they're not going to be able to go to court and say they've discharged their obligations if the work requires substantial amount of things to finish it. Okay, does that kind of make sense? And usually these situations happen, by the way, where one side it kind of begrudgingly accepts the work that's been done. And this can happen in situations where one side's kind of left or abandoned or gone away. So 98% of the work is done. Courts are going to consider that to be actually discharged through performance, but you can deduct, just as a practical rule, deduct the amount required to fix it or finish it. That's not going to happen if it's a substantial amount. There is a rule, and I actually touch on this twice in this class, where one side to a contract has started doing some work and then just abandoned, disappeared, gone AWOL. And so the example here is Sumter and Hedges. And this is actually called the rule in Sumter and Hedges. The reason for that is that this is actually an equitable rule. It's not a common law rule. So again, usually situations that parties have to come with clean hands and they can't take too long. And the key thing here is that there was a property or a house that was being built and the builder started doing some work on it. And then they said, I can't do this anymore. I'm not going to be able to complete it. And the key thing to note here is that the other side said, that's okay. I'll carry on. I'll do some more work on it and I'll get someone else to do the rest of it. All right. And so this guy went away. And then later on, he came back and said, oh, can I be paid for the work that I did do? 15% of the work of building this house or whatever it was. And you think in common law, well, the answer is no. You've clearly you've completely breached a substantial breach. And again, we talk about the breach of contract. It's you're not going to be able to be the one, if you're the party in breach, to go and seek some form of compensation from the other side. All right. Here, though, the courts did say in equity, if and only if one party is doing the work and then for whatever reason abandoned the contract, or there's some legal defect that it's not a contract, and the other side accepts their partial performance. So they knowingly and willingly accept the work that's been done up to that point. The side that's done the work can actually go to the courts and ask to be paid a reasonable amount, not the contract amount. If the contract amount would be more. So if you've gone, You've spent some time in there and you say, look, I just don't want to do this anymore, and you disappear. You can actually come back if the other side knowingly and willingly accepts your time, effort, materials, and labor. You can go and seek a remedy in equity. It's quite hard to prove. And like all remedies in equity, it's what's called discretionary. You don't get it by right. You actually have to go to the court and ask for this remedy. And that's different, by the way, from those earlier ones. When I talked about this doctrine of substantial performance, and this will happen for you guys in your life, and I've seen this happen and go absolutely terribly pear-shaped with my father's business, going back about 20 odd years ago, where he was advised, just pay what you think it's worth. No. Don't pay what you think it's worth. Pay what a reasonable person would think it's worth. Because they'd end up going to court, and my dad actually lost. He lost a substantial amount of money as a result. So but make note that this accepting of partial performance, this is a remedy in equity. The other side has to go to court in order to claim this remedy, and it's wholly up to the discretion of the court as to what that reasonable amount is. So those earlier things, the de minimis rule and the doctrine of substantial performance, you don't have to go anywhere near a court. If you know those rules and say, oh look, they've supplied us with these products, they're a little bit faulty, we need to spend some money to fix that fault, we're going to pay you this amount. That's fine. You don't have to go near the court. The other side might want to go and take you to court. They're probably going to lose, but that's up to them. You guys can sidestep the court system in entirety, provided you're reasonable in it. And you know what the worst thing is? As human beings, when we feel we've been ripped off or cheated, or somebody's tried to do a dodgy on us, we get angry, and we're often emotional about it. And so you just have to leave that on the back of your mind. Go and talk to someone else who's not a friend, because your friends are always going to say whatever to cheer you up. Is the amount that I'm paying reasonable? All right, is the amount that I'm deducting a reasonable amount? Okay, all right. Next rule. Just make note, in contracts, this can come up sometimes in contracts, in contract law. All right, so there's a few little rules that I've got to talk about here. It's a bit annoying because they seem a little bit eclectic. But if the two sides are performing their sides of the obligation, I'm doing my thing, we're doing, Jean with the boat, I'm doing my thing to try and get the money, she's doing her thing to try and deliver the boat. If we take active steps to stop the other person from completing their side of the bargain, that's a breach. There's an implied term in all contracts. When you come together, have a meeting of minds that you can exchange consideration, that you're not going to actively work to try and undermine the other side performing their side of the bargain. It seems illogical why you would want to do that, but if you think about it, there may be some situations where, oh no, I've just had a crisis. I don't want the boat after all. Oh no, I said to Jean she had to deliver it in 5 days. If I go and, I don't know, let the tires out in the trailer, or I go and lock the gate from the thing so she can't deliver it, or some doing things like that. Sure, there's evidential problems that you have to overcome as well, but fundamentally though, all contracts have this implied term that you're not going to try and stop the other side from doing what they've promised to do. You've literally entered into this contract wanting them to do it. So that's just an implied term. That applies to all contracts. This can come up where one side or the other refuses delivery. I don't know if has this ever come up for any of you guys in retail or in commercial operations, where goods have arrived, you've inspected them and gone, nah, don't want that, not signing the delivery. Has that ever happened to anyone? Has that ever come up in business or personal provider lives? What happened, Gary, in your situation?
5 containers of ceiling fans.
Ceiling fans. Oh, wow.
They came in, they were the wrong fans.
Oh, wow. There you go. So you go,
No,
not going to do it. Not going to accept it.
Not even legal to sell in Australia.
Oh, wow. Oh, nice. Awkward. And so that's the thing. And the key thing to note when you're doing that, you have to be sure. Make sure when you are choosing to not accept goods, make sure that you do have a valid reason. And that being a good example, checking by opening the things up, documenting it. And these days we've got mobile phones, so just go tick, 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 tick. And then just saying no to the person delivering it. I don't know. I've got a good friend of mine actually does deliveries. I wonder whether that comes up very much. They're not happy. They will not be happy lads. Truck drivers are often big sorts, and yeah, that would be one of those moments where like, no, not accepting that. So just make note, if you are going to refuse delivery, it's a big thing in sale of goods law. It's a flashpoint moment when you say no, because wrongfully refusing to accept means that you're going to be the ones in breach. And as we see later on today, the consequences can be quite dire. They can be dollar-wise, and again, this is one of those points, I'm going to say it now, but I'll reiterate it later. The amount that you can become liable for is often not what you think it is, because I've explained this rule to a lot of lay people over the years, and they go, that can't be right. And I go, yeah, it is. Yeah, it is. And it goes like this, and again, I'll reiterate this later. The purpose of damages in contract law is to put the innocent side in the position they would have been in if you didn't breach. All right, and so if we think about this with the fans, was it 5 containers? 5 container loads of fans. Just straight out of the bat, without thinking of anything that you might have enshrined in the contract, that if they were wrongfully not accepted, so for whatever reason, Gary got his facts wrong, the other side is going to be able to sue, and they're going to sue for a whole bunch of things. What is the situation? Well, these containers won't be in here. We have to rent this space. Oh, we may have to go and sell these fans to someone else to try and mitigate the loss. Oh, we're going to only sell them for 10% of what we've got for this particular contract. All of those things, all of the costs are going to be borne by the side in breach.
The drivers of those trucks, they
yeah.
can't unload them.
Yeah.
They've got to find somewhere to put them.
Yeah.
They're going to be late for the next loads. And
that's right. And
all it's costing them a lot of money.
All of those things, and if all of these things have been reasonably contemplated at the time of formation, which they often are with things like shipping and transport stuff, then the other side can be liable for a very, very large bill. So just make note for anybody in this room, if ever you're in a situation where you're not accepting goods, make sure you got a good reason. Good reason. And that kind of, we go back to that bigger picture idea of the wheels of commerce turning. Generally, we want people to be buying and selling things, and paying a little fraction of tax to the government, and just repeating that process many, 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 many times to build up a big, strong economy, people doing stuff. And so in situations where that happens, as Gary rightly pointed out, you've got all sorts of other flow-on effects by not accepting goods, all of the other costs that are going to flow from that. Make sure you do it properly. The other thing to note here is this situation where the other side say they are not going to accept goods, or they're not going to do their side of the bargain. All right, so just that's on foreign and right. And often said, this comes up in situations where we've called up to say, look, if you're going to deliver these, for whatever reason, we found out fans are wrong in transit. If you're going to deliver these fans, we are not going to accept it. All right, so in that situation, if that you've been given notice the other side is not going to perform, you don't need to carry on actually taking all of your goods to the docks and leaving them there and then trying to find somebody to sign this form. They've intimated earlier. And again, it's to try and be as efficient as possible in terms of doing it. Don't get me wrong, there's going to be a breach. There's going to be some dollars flowing one way or the other, depending on who's right and who's wrong. But just make note that being told that you don't have to perform from the other side, clearly and unequivocally. And what's the first thing that we do if someone calls up over the phone saying they're not going to perform? What's the first thing you get them to do? Contract law students, business students, what's the first thing you do when somebody calls you up? Jackie, get it in writing. Get them to send it in writing, because that is going to become an evidential thing. And if, I was going to make some funny joke about excrement and fans, but that's just too pertinent. I can't. I'll try and think of a better way of putting that together. If things are going to go pear-shaped soon, make sure you are on the side that has everything written down and in writing. That's exactly where it's at. All right. Now, sometimes in terms of performance doesn't necessarily start when the contract's formed. Sometimes you can have in a contract that says performance for this contract will only begin from one or both parties when a certain thing happens, when a certain event or a certain time passes. So say, for example, I've got a contract with removalists. Removalists, I need you to move my furniture, all right, to this new house I'm buying. When is that contract? And I can pay in advance. I could prepay, for example. So my performance is discharged. I've already paid. When does their performance come into existence? When they can actually have access to the new house. That's a contingency or a contingent term. And just make note that sometimes you can have terms in contracts that, again, we call these contingent precedents. That can last for an event that we don't know when it's going to happen. Can you please come and collect? I'm trying to think of something involving water on a farm. Can you come and empty the dam and collect water from the dam when it fills up? When it fills up, that's right. And the next time it rains, come the day after it rains. And if it could rain the next day, or it could rain in a week's time, or it could not go for years. And the courts have said that, look, these contingencies can't last forever. There is actually a statutory rule, rule of perpetuities, which is 80 years. So it's difficult to have things that are going to, a contract that's going to last over 80 years for a certain contingency to happen. But the courts just say, look, things have to vest or happen within a reasonable length of time. And that really depends what the particular circumstances and the type of contract is. So, say for example, having a contract that a friend of mine, she's a law student, she gets the gig to do merchandising for a particular Kiwi band called Catch a Fire whenever they come to Townsville. All right, she gets this gig. Now, she doesn't have a long-term contract, but in theory, there could be one saying, whenever we come to Townsville, we'll pay you this much for you to man our stand. And this has happened 3 or 4 times. But in theory, they might not ever come back. And so Lani can't just go to the courts in 6 years' time and say, oh, it's a reasonable length of time's happened. I want this to happen. Like, the courts are just like, no. These contingent clauses, we're not going to deem them as necessary to be done. The contract will simply come to an end in those situations. Okay. And another one, that's, by the way, that we call those conditions precedent. So when obligations start, when the event happens, but you can also have the opposite of that, where obligations for one or both parties cease when a certain event happens. So you can, carry on selling all of this merchandise on your website of the Queen until she dies, for example. At that point in time, we'll have to redo it and put someone else's face on it. That's what we call a condition subsequent, and that discharges your obligation to discharge at the length of time at that particular point in time. Okay. So all of the things I'm talking about there is discharging through performance, where the sides do what they say they're going to do, or some rules say that, look, we're just going to deem at law that the sides have done what they said they're going to do. Their obligations are discharged because they did the thing they promised. That's kind of the easiest one. Question?
What does it mean by the contract? I mean, the court will give reasonable period of time having regard to the circumstances.
Yeah.
It means even if something does not happen, after a reasonable period of time, performance should be done.
It means that the contract is going to be, performance is going to be considered discharged. And the type of contract, what they mean there is they look at the facts. So something like the rain, for example, come and empty this tank out. You get to go and clean a tank out after it rains, or it has a big flooding event, and you need to do this. And that could be 1 year, 5 years, 10 years. If it doesn't happen in 10 years or something like that, the court's going to say, look, we're just going to deem this to have been discharged. We're going to discharge the obligations of one or both parties under that contract. And sometimes those timeframes might be shorter. I'm trying to think of an example. Again, Lani's one with the with catch a fire coming. If they don't come back in 10 years, the courts are just going to say, look, that obligation for them to pay you when they get here, we're just going to consider that discharged. Reasonable length of time's gone by. The contract comes to an end. Contracts can't last forever. That's really the key point that I'm trying to get across with that one.
Like almost, let's say, health insurance is usually taken for 1 year. So
oh, health insurance. Yeah, the insurance contracts are a little bit tricky because the whole purpose of the business model for the insurance companies is for them to take money periodically and then pay you when the rare event occurs. All right. And this is different, by the way. And I am actually going to talk about this. This, for all those, and this is most of us in the room that aren't from Australia, Australian English, very unfortunately, uses the term health insurance wrong. When you guys, for most of you guys on certain visa classes, you'll have to take out insurance, right? As a Kiwi, I'm in New Zealand here, I think I was always eligible for Medicare on a long stay visa, but we had to go and get medical insurance to stop. There's a surcharge. You actually pay a surcharge in your tax if you don't get insurance by the time you're 31 and so on. And so I went to get medical insurance out, and I went backwards and forwards for ages and ages saying, I just want insurance. Because they would keep telling me, oh, you get to claim this, and you can claim this and claim this. You get this much for optics and this much for dental. And I'm like, I just want insurance. And it wasn't until I'd done this a few times when I realized when in Australia they use the term medical insurance, what they actually mean is a scheme. Because and this is, again, for you guys, yours might strictly be actually just the insurance component, whether or not they're scheme. But for people that are on the Medicare system, getting private insurance is putting you on a health plan, essentially, so that you are paying a certain amount of money and you can claim back a certain amount of money when you go and buy contact lenses or dental or do all of these things. The idea being that they want to encourage people to go and see medical practitioners and psychologists regularly. It's to try and get people to be healthy. But unfortunately, they bundle it all into the same thing because the word scheme has a lot of very negative overtones to it. When you sound like you're on a scheme, it sounds like trying to dodge your taxes or something. And so that's kind of unfortunate. So just make note for those, most of us, coming to Australia, I got unstuck by that particular rule. And also when someone crashed into my car, and they talk about personal injury insurance. This is probably just Kiwis, because we don't have personal injury law in New Zealand. There's no personal injury law. So that when somebody told me I had third-party insurance, when I paid my rego, I was stoked. And when I crashed into something, or somebody crashed into me, I'm like, I'll just claim on the third-party insurance. No, because that means personal injury in this country. Yeah, I got unstuck. So just be mindful that even technical words in English, and like this is the difference between New Zealand English and Australian English, so just be mindful. These technical terms can have quite different meanings, so that can be a little bit confusing as a trap for new players. Anyway, come back to that. That's just my gripe about the Australian English for the day. Got some more later. All right, so another way we can discharge obligations, or rather, maybe it's the way we don't want to be discharging obligations, is through breach. That is where one side either fails to perform or demonstrates an unwillingness to perform one or more obligations under a contract. So when they either don't do something, or they tell you or demonstrate to you or a third party that they're unwilling to perform contractual obligations. That is a breach of contract. And this is really important to note, any breach of contract gives the other side a right to sue for damages, money. All right, so that's the first thing you need to know. Very important rule. Any, breach gives the other side the right to sue. All right, that's it. Look, sometimes it may not be very much money. Here's $100, go away. All right, but strictly speaking, the rule of contract says a breach of contract always entitles the other side to a money remedy. Now, that's nice to know. It's good. we don't want to go to the courts just to get $100. What we care about is what we call the quantum, the amount that we're able to get from the other side. Okay. And so in order to calculate this, we actually have to determine what kind of breach has happened. Because this goes back to the seriousness of the breach of contract. Because again, the courts are not the destroyer of bargains. If there is a contract, I'm buying this boat off Jane and paying $10,000, and we've swapped the $10,000, I've got the boat, and it turns out that it's got a big hole in the bottom and it can't float. We reckon that's a serious breach? Yeah, probably. Seems like pretty well. What if it had minor discoloration in the sails? It's a minor breach. It's a minor breach. That's the sort of thing. But strictly speaking, it's a breach. If that was something we'd stipulated as part of the contract, again, it has to be a term. We're talking about breach of contract. It has to be a term in the contract that says the sails will be pristine. And we turn up and they're a little bit faded. That's a breach. I'm entitled to money. Some amount. Might only be really small. Courts might say, okay, Mr. Walker, yes, your rights have been infringed. Here's $100, go away. Sorry, they're not paying $100. Jane has paid $100. That's fundamentally, if you get that around your head, that is how it works. It really is. That idea. Now, key thing to note though, is when we're working out this seriousness, it's not just a dollar amount. I mean, that is a big part of it. So a big hole in the bottom's quite a different dollar amount than mere discoloration on the sails. But the really important thing to note is that the courts, when they look at these two categories, we call the minor ones warranties. So that's a technical contract law term to describe a minor term. And the technical definition of that is a warranty will only give the innocent side a right to get dollars, to seek compensation, get damages. And that is to be contrasted with the other type of contractual term called a contractual condition. A condition is a major term. It's something that if one side entering the contract would have known that this was going to be breached, they would never have entered into the contract in the first place. It's substantial and goes to the heart of the contract. That, if it's breached, actually gives the innocent party the right to terminate. To actually say, no, we are terminating at this point. We are going to go and seek compensation through the courts. Or, in the case of the boat, for example, if I haven't paid yet, I am not going to pay. Right, this boat's got a hole in it. It's a substantial breach of the contract. Here's your boat. I'm not going to pay. All right, that is what we call a contractual condition. And again, we use that as a technical term. And really unfortunately, in common speak, in Australian English, those terms are used all over the show in actual real-life contracts. You will see things called warranties. We hear about warranty. What does a warranty mean in general parlance? It's usually a list of things that, the ones I'd usually selling goods to you, guarantees of some sort of a guarantee. It's not actually the contract law meaning of the word warranty, sadly. So first thing to note, when you hear that term from this point forward, there is a specific technical meaning of that word in contract law. Warranty is a minor term that, if breached, only entitles the innocent side to dollars. And the word condition also has a general purpose meaning, which is usually, condition is usually used to just describe terms broadly. These are the conditions that you enter into this arrangement with us. What they mean is these are the terms, which is confusing as, but just make note, for the purposes of contract law, that is what these two words mean. Okay, so if just for the duration of the subject, or if you're having to deal with your lawyers at some stage. Oh, I remember that, yep.
Is there a time frame on when you can find, like with the boat, if it was a massive ship, like a cruise liner,
Yep.
and you didn't find out about something
Until later, till you've already paid.
yeah,
Yeah, no,
and
yeah.
it's a breach, but is there a time frame of
Yeah, kind of. Usually things like that, if they're large, they're often mapped out in the contract themselves. The thing is with boats, big boats, is that the people building them and the people buying them are powerful players. And they have usually well mapped out in advance contractual terms stating exactly for each part and each bit in terms of timelines, in terms of quality, in terms of times to inspect for each of those things. And so a massive failure that would occur that you find out at some stage later, it can be. You can often find that things like that you don't find out until later, and you may have paid some or all of those things. And yeah, and that's fine. And there is a reasonable length of time for you to go through and do that. But just make note, the really, really important rule that comes in Sale of Goods Act, which is to do with title. Again, I'll talk about it next week. That by default, once title to goods passes, which usually when you accept the goods after you've given them an inspection, by default, Parliament has jumped in and said breaches of conditions are considered to be breaches of warranties. So yes, you can still sue, but the boat is still yours. So going back to the boat with Jeans, that usually with that sale of goods things, and then once I've accepted the boat, right, the title is passed, and I must treat these breaches of conditions as breaches of warranties. That's a statutory rule. I don't talk about it today. Well, I just did, but and that tempers this part here. Because even though, oh no, there's a substantial hole in it, but if I've already accepted it, it's going to be too bad. Buyer beware in that situation. And that's why these things you have to have a reasonable opportunity to inspect the thing at that point in time. Because once you've accepted it, well, not all bets off. You can still go and seek compensation. Oh look, I wanted a boat. Implied term that the boat would float. Maybe. That's a breach. But it's going to, and it would have been a condition because I would have never bought a boat that couldn't float. But if I've accepted it, then I have to treat that breach of a condition as a breach of warranty, which means I can only get dollars. Look, it might be a lot of dollars, but I can't give the boat back. That's just a key thing to note with the sale of goods stuff. All right, and that's fundamentally what this part's about. Look, again, it's a pretty important rule. These things to know, and just make note, things in the Sale of Goods Act can be contracted out of. You guys might have heard of what a Remalpa clause. Remalpa clause is something. It's funny, I learned it when I did business law, and yet it never really came up when I did law, when studying contract law. Maybe only a tiny little bit. It's quite a common thing when you're selling goods to people that you're not completely sure they're going to pay, for you to actually have a clause in the contract that says title doesn't pass until you've paid. What that means is if the other guys don't pay, you get to come in, pick your goods up and take them away. And you'll get preference ahead of other creditors because the goods still belong to you. So you can, when I talked about that Sale of Goods Act, that's the default rule. Can put in your contract things to trump that, to actually contract out of that rule. So with me and Jean buying this boat, if we'd put in our contract, title doesn't pass until paid for. When she delivered the boat, all right, and then I don't pay, she can walk into my place, grab the boat, walk out again. It's her boat. Title never passed. That's a key thing to note. And again, I'll talk about it a bit more next week. All right. So in some situations, though, when we've got this clear division between warranties, which you only get dollars, and condition, where you get dollars as well as this right to terminate the contract. All right. There are some things in between, and we call those intermediate terms, where a little breach is going to just be considered a warranty, and a massive breach is going to be considered a breach of a condition. And the classic example of this is time. Delivering goods 3 minutes late, sure, strictly speaking, that's a breach of contract. Sure, that may actually be problematic. You might be able to sue. You might be able to go and get $100 from the courts. If you can't prove that you actually suffered harm, it's not going to be more than $100. 3 minutes. But strictly speaking, if goods were delivered late and you had 17 staff waiting to unload these goods, actually, Justice, I don't know, does this come up in any of your situation with your businesses? Justice, have you had that situation where you've had staff and you've had goods coming to or from, and they've come late? Has that ever come up for you? and it's like that, and you've got to pay your staff. Yeah, like that. So that in that situation, even though time might be considered intermediate term, in that situation, that 5 minutes, that can add up. 5 minutes, 15 minutes, half an hour late. I mean, in Australia, you 4 minutes, maybe not so bad, but when you're starting to actually get increments where you've got to pay people those amounts, those things add up. And so that's why. Oh yeah, complaints. Yeah, like that. Them being late, they have very complex arrangements with the various airports, with all of the contractors that they have. But because it's such a lucrative thing for these contractors, I don't know if anybody's dealt with contractors with the airlines. If you've got those sorts of gigs, a lot of the suppliers, they get squished down a little bit and negotiated pretty heavily with. And you'll find there's a lot of owner-operator businesses that go and do things in and around there. The reason for that is that sometimes with staff, particularly in Australia, a high-wage economy, can be really problematic with people that have to wait. Airlines where they have their staff have got to have minimum breaks. So the staff arrive and they have to ship in staff from elsewhere, and it can get really complex in terms of doing it. So yeah, time matters. Okay, a couple of other things to note. Yeah, so time is the classic one. And the example, I don't have it in there. Eagle. Oh, where's the next slide? Just to see if I've got the next slide. Oh yeah, it's on the next slide. So just make note, where it's got this, whether the breach is fundamental is a question of fact. What that means is that that's for the judge or the jury. We don't have a jury in civil trials, so it'll be the judge trying to determine whether the thing is reasonable or not. And they look at what was foreseeable in terms of time, for example. So delivering your goods late, having the staff having to wait, to wait later, that is something that's foreseeable at the time. But delivering the things late, and then all of the staff have gone home. All right, that might not have been foreseeable because there was a union strike or something along those lines. And the staff were all told by someone else that they had to go home. There's been a breach. Maybe it wasn't foreseeable that all the staff would leave, but nonetheless, it actually happened. And so that's with all of these things. You can say, well, that delivering late in that situation was a really, really big, bad thing. Therefore, we are going to treat it as a breach of condition. Therefore, the innocent party gets a right to sue, to terminate the contract, as well as sue for damages. That coupon, oh dear, they're tricky, some of these words. Kumpalu, Local Aboriginal Land Council and Sandpine. That's a situation where you've got a small breach one day, and then another small breach the next day, and then two more small breaches the day after that, and then another small breach after that. And the court's there said that, look, strictly speaking, each one of these is only a breach of warranty, but collectively, lots of small breaches is going to add up to essentially giving the other side the right to terminate. All right, so that's just something to make note, that if somebody is late by 5 minutes every single day, each one of those is only going to be a warranty. You're probably not going to get much money for it. But if they're 15 minutes late one day, 10 minutes late the next, 15 minutes late after, even if those things are a breach of warranties collectively, and again, going back to that thing for you guys, taking notes, make sure everything's written down, collectively that can actually give the other side the right to terminate. All right, but also note with a lot of these things, if you map the stuff out ahead of time, you can actually come to an agreement. This being up to this amount of time late each day is considered a warranty, but being this late is going to be breach of condition. Parties can put whatever they like in their contracts, and the courts can use that to help analyze those. All right. So, I've always found these ones to be kind of a little bit funny. The reason why I found them a little bit funny is that this Union Eagle case, have I got another one there? No, I don't. Union Eagle, yeah, no, that's right, it's Hong Kong. It's a Hong Kong case. AC is the appeals cases, it's the Privy Council. And these are both actually to do with property settlements. All right, and it turns out a property settlement that says the property is to be settled at 5 p.m. on Friday. What happens if you rock up at 10 past 5? Yeah, in certain situations, they can say, and it's been stipulated, time is of the essence. This is a phrase, you will see this in contracts, time is of the essence. What that is saying, we are making time a contractual condition of this contract. Because by default, it's that second clause there, that if it's not agreed upon, it's an innominate term. Small breach, not going to matter. If you say time is of the essence, the courts will hold that strictly. And with things like settlements, if you have a very small delay and you rock up late, too bad. Union Eagles, it was a Hong Kong case, and yeah, they came to settle, I think, 15 minutes late. Remoteness was a case in the Gold Coast. It was a conveyance. It was supposed to happen at, I think they were supposed to do it at 11 o'clock in the morning, but the contract said by 5 p.m. that day. It was a Friday, of course, because if you think about it, 5 p.m. on Friday is a really dumb time to settle, to do a conveyance. That's a really dumb time to do it. Why? Because if you miss, you're going to miss by 2 or 3 days rather than being able to do it the next day. So that's just something that's a trick for small players. I mean, this was on the Gold Coast, and there was an electrical storm, and the titles office computers were down, so they couldn't affect the digital parts of the transfer, and they had to drive from, I think it was actually from Brisbane to the Gold Coast, which is a trip I haven't done in years. How long does it take usually? About 40 minutes? I've got no idea. An hour? Has anybody driven between the Gold Coast and Brisbane? Anyone in this room? I don't remember how long. Yeah, I get it, particularly if it's raining and there's traffic, and I think it's about 40 minutes, 34 minutes. I don't really know. Oh, of course. Yeah, Brisbane's not a huge city. Yeah, sure. I was thinking the CBD, but yeah. In this case, it was the CBD because there was a law firm. They went, they were driving from one to the other, and there was just an electrical storm. Traffic was hell, and they rock up at, I think it was 5:25, and I think this was before cell phones as well, so I don't know whether they were called the office. I think they had called the office to say, look, we might be late. And they rock up, and yeah, it's 20 minutes past 5, and the other side said, nah, we've terminated. We're going to seek compensation for you guys for being in breach. And that's what they did. And this went to the Queensland Court of Appeal, and the Court of Appeal said, yeah, that's right, they are. Time is of the essence. You both agreed that time is of the essence, and then one of you breached. So the other side can terminate the contract and seek damages, and they did, and they won. All right, so just make note that second part there, if you guys are doing any form of contracting and reading and putting things in contract, make sure you know that fact. Make sure you know in a contract whether time is of the essence. It will be in contracts, and this is probably the first actual interpretive thing that you can go through armed with this piece of technical information to determine, because that will impact the obligations of the parties and dollars if they don't do things within the time stipulated. All right, time is of the essence. Sometimes, and I had this weird one, which was the assignment question for this subject last year, where they said, oh, apart from the time of delivery, time is of the essence. It's like, oh, okay. Time of delivery, is that getting the thing and putting it and packaging it up, or was it just giving it to the courier and them delivering it? It was a little ambiguous. And remember, what's the rule that's saying if something's ambiguous? Contra preferentum? It's a reasonable question, but assuming there's still ambiguity when we're reading it and we've looked at it objectively, we can't determine what it is. Who gets to win if it's still ambiguous? The side who didn't draft the contract. It's the contra preferentum rule. If assuming that it's ambiguous, even after doing all that other interpretation, that objective intention test. And just make note that is enshrined in the Sale of Goods Act if it's not specified. So if you're buying goods and it's not specified, time will not be of the essence. It's an intermediate or an innominate term. So a small breach, not going to let you terminate. Big breach will. All of this stuff. Yeah, there's lots of this whole subject. Yeah. Yeah. it's interesting actually, just in terms of reflecting on that. It's obviously I've taught this like many times now, and I always found it really interesting. Steve Grower, who wrote the book, I remember one year I was the tutor for the law students teaching this stuff, and he could just walk in and didn't need any notes, and could just go through and read and talk about all of these cases that stuck in their heads. And I thought that was just bizarre. And then after teaching it a couple of times, I thought, oh no, now it's all in my head too. It's terrifying. It's hard for you guys. I think the hard thing, I found as a business law student myself back in the day, the hardest thing is trying to prioritize what are the most important things. And so there are some parts that I talk about. The postal acceptance rule, forget it. Once you walk out of the exam, forget that rule forever. The things that you should remember, ironically, are the stuff from this particular lecture. And I don't say that every week. Some things, there's a little bit from each week, but the rules for damages, dollars, matter, because these things are going to impact your life. That's really the key part. The stuff to do with formation, elements of a contract, you're going to know most of the time whether you've got a contract. It's the document that you've both signed. That's not going to be a big thing. Undue influence, unconscionability, all of the vitiating factors. Apart from people lying to you, those rules are nice to know. But the key thing is, in terms of dollars, is the main time these things come up is when people don't do what they say they're going to do. And so time, I think time's a pretty important one, because knowing whether or not being 5 minutes late, I think it's a pretty handy thing. This may well come up. I'm not trying to say, because I hate it when people say, oh, everything's important. No, not everything's important. I've got to teach you everything. But I find in terms of the way I weight the assessment for your exam, I often weight it towards the stuff with a bit more, I don't like to say practical bent, but the stuff you're more likely to come up to in your lives. When somebody is conveying a house to you, you're buying a house of somebody, they rock up late to settlement, and your lawyer calls you up. What do you want to do? It might be nice to know to say, nah, we're going to terminate and we're going to get some dollars out of them. It may not be very many dollars, but knowing that you can do that gives you power. And I think of these things in terms of just the power dynamic. You guys knowing this is going to make you more powerful as people. I taught administrative law last semester. That is literally the most horrible thing, because this is a subject that turns lovely, lovely, sweet little dear 18-year-old law students into terrible human beings that are now the bane of Centrelink and the bane of the tax office and all of the government departments because they know the rules. That's horrible. But I'm hoping you guys will use your powers to be generous and do good things in the world. I might just take a break there anyway, guys. Breakthrough delay. Because All right. Benson. Look, when I said that that time being of the essence is something the parties can map out in the contract itself, there are going to be some situations though where even though we don't discuss it, it's going to be considered to be of the essence anyway. And so, for example, if we have a contract to build a viewing platform for the coronation of the, well, I presume it'll be a king next time, and we don't explicitly say that time is of the essence, but there's a point in time when the coronation is going to happen. Just by sheer force of logic, it has to be. That's just the, and so it's kind of like a factual analysis, but sometimes it's just by definition that is going to be a requirement of that contract. Now, other thing to note with time being of the essence is that you can, in situations where you haven't talked about it, actually tell the other side from this point forward, we want it to be of the essence. Look, we didn't give you a time to stipulate as such, we said a reasonable length of time, but we want from this point forward to really kind of encourage you to hurry up. So just make note that if the other side in a contract does appear to be tardy or slow in situations where you haven't specified a time, and you haven't made time of the essence, you can give clear, unequivocal notice that you wish, even though this is after formation, you want to make time of the essence. And not only that, you can map out ahead of time what the consequences are going to be, both to ask them to do things, but also instructing them that if, and I'm not meaning this in terms of threatening them, if they don't do it by a certain time, for example, we're going to have to go and find third parties to complete this particular thing in order to achieve our particular business results. And as such, that cost is going to be borne by the side who are being tardy, that are being slow. So just make note, you can do that at a point in time in a contract, as long as what you're doing is reasonable. You can't just turn up, put time isn't of the essence and then 2 minutes later give notice. The courts will just ignore your notice. Your notice is going to be void in that situation. But if things are happening and you perceive the other side is taking too long to do their side of the bargain, and you want to give them some impetus to actually speed things up a bit. So that's something that you can, as a practical step, do. All right. Next thing I'm just going to talk about is what we call repudiation. This comes up where one side demonstrates that they do not want to, or they cannot substantially complete their side of the contract. So that's where the other side demonstrates, gives some form of clear indication, and either an unwillingness to perform or an inability to perform. Okay, and look, it has to be crystal clear. You have to be really, really careful there, because, and this is the key thing to note, strictly speaking, if the other side is demonstrating this, that they are unwilling or unable to be substantially bound by the contract, they're in breach. All right, and you at this particular point get to elect to either terminate that contract at that point in time, or to keep it on foot and to actually go and usually do things like find alternate third parties in order to get that particular, find third parties in order to get their existing contractual obligations completed. All right, so there is a test there. I'm not sure what the name of this test is. Test of repudiation? I'm not really sure. The previous test, by the way, which I'll come back to. All right, so that this idea of that they're either not doing all of what they said they're going to do, or they're not going to, or are unwilling or unable to do a contractual condition. In other words, a major term, major promise. They're not going to keep that up. Or they've got an unwillingness and an ability to not perform, or substantially not perform, a whole bunch of small things in relation to the contract. So again, that goes back to that COM Part 2 situation where you've got a person that breaches one day, breaches another, and you've got real, clear indication that they're going to carry on breaching each day of this contract as it remains. All right, that's lots of small breaches in the future. You, at that particular point in time, can go, aha, they have renunciated this contract. They've renunciated substantially all of the little obligations. And the contract at this point is considered repudiated. Now, you have to be really careful. And the reason I say that is that if you treat the contract at that point as being repudiated by the other side, hey, look, they've demonstrated to me an unwillingness to perform. I'm going to consider this contract at an end. I'm going to just give notice of termination. If they turn around afterwards and say, no, we completely intend to perform, and you've gone off and not done some things or not paid your bills or what hell have you, you've got to be really careful, because if that happens, you are now the side that's in breach. You're going to be obliged to compensate these guys if they can demonstrate that, in fact, they were able at all times to complete substantially the most of the obligations under that contract. That's just one thing to leave in the back of your mind. The other side showing that they can't do it, you have to be clear. It has to be clear and unequivocal. And again, written. Getting things in writing is huge. Can you guys deliver this by this date? If you can't, we're going to have to go somewhere else. This is hard, by the way. And to go back to Jackie mentioned, that this stuff is tricky to try and get inside your head. It took me a few goes. To be honest, it was actually until the second or third time I taught contract law when I really sort of mapped this out in my own head. The key thing to note, don't be the party at fault. Because if you think the other side's at fault and you're wrong, you become the party at fault. And in contract, if you're in breach, the other innocent side can always get dollars. They're always going to be able to get dollars from you. So just make sure when you are about to terminate a contract, because the other guys don't look like they're going to be able to complete, make sure you are in the right. Okay, make sure that you are genuinely. And there's another rule there. Actually, I haven't got it on the slide for some reason. That you have to. Oh, no, sorry, it's on the next slide. You have to be what's called ready, willing, and able to perform that side of the contract. And this can come up in some situations where the other side, look, they've demonstrated that they can't fulfill their side of the contract. All right, they can't. We've got to build some houses. Turn the other one off. I only have half aircon. We're going to build some houses. All right, and we're the developer, and we've got to buy some building materials and get some builders. Now, the builders, turns out they've had some a whole bunch of work as well. They didn't finish their previous work, so they're going to be late. They're in breach. We've got some clear stipulations. Our properties need to be built by this point in time. These guys are in breach. They've demonstrated a clear unwillingness to do this. What would happen, though, if we hadn't got the development permits? So we couldn't actually proceed with our side to actually have the land all cleared. Well, what that means is that we can't hold them to that breach. You can only do this, electing to terminate the contract, if we can demonstrate that we could have actually, at that point in time, completed our side of the bargain. All right, and the phrase they use is that you have to be ready, willing, and able to perform. If you can't do that, you can't terminate. You're still bound by that contract. And if you choose to not be bound by the contract, strictly speaking, you're going to be the ones in breach. You've got this tricky situation with contract law. Often, by the way, in that situation, usually these things come to a head by agreement. But it may be a situation where the other side is going to be a little bit quiet about where they're at. Because this ready, willing, and able rule, the whole point of it, by the way, is to stop people creating contracts to put others into a situation where the whole thing was going to be impossible anyway to pull off, and being able to seek some sort of compensation, even if they couldn't live up to their side of the bargain anyway. All right, so that to bring the action, you've got to demonstrate that you are ready, willing, and able to perform. And so just be mindful that sometimes that information might not be open or public. But there is an onus, by the way, on the side bringing the action to do that. But when you're dealing with and making negotiations in terms of breach, because remember, a lot of these things get settled out of court. That rule, you're going to be the ones that have to demonstrate it. If the other side haven't done what they said they're going to do, they're going to be able to come back and saying, well, you didn't get the permits anyway. You hadn't cleared the land out. You were behind too. Therefore, you can't terminate at that point in time. The contract is still considered to be at foot. And so, yeah, often these things, they'll end up being, through agreement, they'll come out. Yeah, that last thing there, that's the warning that I'm making there. Make sure when you are going to terminate the contract, because the other side doesn't look like they're going to do what they said they're going to do, make sure you're right. Make sure you're right, because if you're wrong, you are going to be the ones at fault, and you're going to have to suffer as a result. Oh no, extra slide. Okay, that's breach. I think I only have one slide on this next part. Yeah, there is. The next two, one slide, maybe two slides. Oh yeah, not much at all. So the next three, those are the two main ones, by the way. The two main ways that contracts come to an end is by breach, or usually through performance. The next three, you don't have to remember. So going back to Jackie's point about things that you need to tuck away in the back of your mind, people breach contracts all the time. You need to know and be aware of it and some of the rules around it. And that don't be too hasty if you think they're going to breach. You can, strictly speaking, you can if they've demonstrated it, but don't be too hasty. And make sure you've got your facts right. So the next three slides is other ways contracts can be discharged. The first one is by agreement. Guess what? If both sides agree that the contract, we want to each release each other from our obligations under the contract, we can do that. And the way that you do that, though, if we kind of think about it, what is a contract? Well, an offer and acceptance of an offer to exchange consideration. What's the consideration that we're offering? Each of us is offering to discharge the obligations under the original contract. That is what we're offering. Whether or not some additional amount might be paid by one party to the other, that's up to the two parties to determine between themselves. All right, that's the straightforward way that contracts can come or be discharged through agreement. That's pretty straightforward. All right, and just make note that, yeah, if the amounts are quite large, doing it by deed is a pretty common way of doing it. The reason why deeds are a special form of agreement that have the same power as a contract, but they don't, strictly speaking, require consideration. A deed is a solemn document that you have to be witnessed. You have to swear. You actually do a little oath when you do it. You've got to do it in front of a JP. And it's a formal, very, very, very formal thing that actually has criminal. There's actually a criminal penalty if you lie, commit perjury under a deed. So just make note. That's why it's a very solemn document. When you go through, you don't, when you put things in a deed, you make sure you're doing it properly. And often it comes in situations where you want to have a contract with somebody, you can enter into a deed and then just exchange deeds, and that's it. And that's the end of it. Also for things like when you are saying to another side, I'm not going to sue you. So discharging stuff, usually for a sum of money. They often make you put that into a deed to say you will not bring an action in the court. It used to be with land law with lands used to have things called title deeds. We don't have this anymore. You might hear that phrase being bandied around. There's no such thing as a title deed in any jurisdiction in Australia anymore. And a deed was simply a solemn document that says that this particular person, the person before them, the person before that, owns a particular piece of land. You don't have that anymore. Now, that's a pretty straightforward way of ending a contract. Both sides agree. Pretty easy. What is a little bit trickier is that rather than having the contract come to an end because we both discharge our obligations, we'll keep the contract afoot, but swap one or both of the parties. So essentially, we are creating kind of like a new contract where we're moving one of the parties in for a third person. Third person comes in and they essentially take over that party. We call this novation. That does come up again. It's a pretty minor point. That's the only point I have to make on it. And strictly speaking, it extinguishes the original contract and creates a new one with all the exact same terms, obligations, and positions of the parties. You can do that. I think novation has to be in writing. I believe. I think that's not on the slide. All right. So ending a contract by agreement is pretty easy. There's another rule. Again, sometimes I've seen in contract law courses, this is talked about for ages. It doesn't need to be talked about for ages. One slide. That's all you need to know. And the reason for that, it doesn't come up very much. Contracts can be discharged when something happens that completely destroys or undermines the subject matter of the contract. And this is the key bit, why it doesn't come up much, is completely unforeseen by the parties to a contract. This is pretty rare that comes up. Usually things where they come up, parties are usually foreseen. So an example where this did come up, it's the second one, Taylor and Caldwell, which is where a contract to hire a hall for a concert, neither side could have foreseen at the time of formation that the hall burnt down. And they didn't map it out anywhere in their contractual agreement. And the courts there said, look, this is one of those situations where the obligations are discharged through frustration. What that means is that at the point in time, this is quite curious, at the point in time where the parties become aware of the frustrating event, all existing obligations are considered to have been met, and future obligations are discharged. Everything you've done up to this point is considered to have been met as part of the contract, but everything that hasn't been done so far is discharged. This can actually lead to some, as you could imagine, some quite inequitable results, pretty unfair results. If, for example, one side has paid, the guy's already paid to hire the hall. And so, look, there are principles you can use to recover money, right? Get under equity and so on. An unjust enrichment, but they're not part of contract law. So it's just thing, mate, to note that if you've paid and this thing comes up, and again, it's pretty rare. If you're going to have a contract to do something like that, you expect the two of you to contemplate or map out some way what's going to happen if the band never turns up, for example. U2. I bought tickets to go to U2 on St. Patrick's Day about 10 years ago. I was so excited. We booked to go and leave, had to go to Auckland, drove up to Auckland, had it all ready to go, and then the band's, the singers, the bassist's mum got sick or something like that, so they didn't tour. So was that discharged by frustration? No. Why? Because it was already mapped out well in advance in that contract itself. Frustration's rare because it only happens when it's things that we haven't talked about, we didn't think about at all. Okay. Yeah, and so the two, we call these the coronation cases. The undermining the basis can frustrate a contract. That was to do with the coronation of, I don't know who. Edward the First or the Second? Seventh? Second? Seventh. Oh, really? Seven? Is that what it was? Okay. It was around the turn of the 20th century. 1903, yeah. So after Queen Victoria died in 1901, and so was it the one after? It was after. I don't know. I'm not very good with them. They went through a bunch. It's bizarre that my own parents' living memory. They're born in the 50s. They've only known one British monarch. It's really weird. Anyway, these two cases were where people had booked, I think one had booked to go on a boat tour, and the other one had booked to go over a viewing platform, and they were heard together, these cases, because the courts used it as an opportunity to talk about the doctrine of frustration. And there, the coronation, because of bad weather, no, I think he got an illness, appendicitis or something, it might say in the textbook, and either way, the coronation got delayed, got put off for a few months, and so these contracts that had been formed, the courts talked about whether they were frustrated or not. And there they talk about, in those cases, that look, undermining the fundamental basis of the contract can frustrate a contract, but it only applies if you didn't map it out in advance. All right, so that's why frustration, I think, is not something that I spend a lot of time teaching or talking about. When I set the subject as a student, we talked about this for a lot. I don't think you need to talk about it for a lot. There's not much to it. It very rarely happens, because it has to be something that neither side's thought about, and that completely undermines the contract. It's pretty rare. All right, contracts can also be discharged through operation of law. Basically, when usually statutory rules, oh no, there's common law rule as well. Statutory rules come in and just, let's start again. Contracts can be discharged through common law and statutory rules, and some of those include bankruptcy. So if you have a contract, usually they say with bankruptcy that the trustee takes over obligations under the contract. So that you guys, I don't know if you guys are aware, I don't know if we do bankruptcy in this course actually. Banks, when a person owes more than $5,000, an individual, more than $5,000, right, either to a bunch of people who have all come together, or one person who has got a little bit grumpy about it, though either those group of people or that one person can ask the court to declare someone bankrupt if they don't pay. Said it's $5,000. And what that means, bankruptcy is, the idea of it is for you to have a clean slate. All of your debts get wiped, but you can't do a whole host of things for a while. So in the meantime, while you can't do these things, someone else has to look after your stuff. Because bankrupts can still have stuff, and all of the stuff that they do have, the trustee in bankruptcy is supposed to actually go through and see if they can work out what of the stuff this person has can be sold in order to repay the creditors at a certain number of cents to the dollar. That's what that's about. Yeah, liquidation is very similar for companies. So if a company gets liquidated, it means that it's taken over. The directors get sacked, and the liquidator steps into the role of the directors, and the whole point of that is to try and pay out the creditors as much as they can. All right, the next two hardly ever come up. I suppose they can come up. There's pretty minor rules. You can, if there is a, yeah, I'm not even sure. Pick its case. Okay. There's two common law rules. Merger is to do with parties of a contract. No, actually, I can't remember off the top of my head. I'll have to come back to merger. But there are some rules at common law that do say if there is a written contract and there is dispute or doubt over it, and there's two documents, there's two contractual documents, that can actually discharge the obligation if you can't determine which of the two documents is the actual or correct one. That can happen often in situations where things have been changed after the fact. You've got a contractual document, one person's just come through and just made changes. That can make, that in some situations can actually render the contract discharged at that point, and render that your obligations at that particular point invalid too. I'll come back to merger later. Limitation periods, you've got 6 years. It's not, strictly speaking, discharging obligations. You can't bring a contractual matter to court from 6 years after the time your cause of action arises, which is usually the time of breach. All right, so that just make notes. 6 years after breach, you can't bring an action in contract law. I'll come back to merger later. All right. Okay, we're a little short on time. So is it all right if we just carry on for the rest of this lecture? I'm just going to go through it. Okay. All right. The default rule with contract law is that if the other side breaches in some way, you get dollars. All right. That is the default remedy. And if you, even though you may want to receive some form of remedy, you may want to see them locked up in jail. That's great. You may want to actually make them do or sell you that car that you really wanted or not. But the default rule is you can't do those things. You're going to get dollars. All right. Now, this, again, when I talk about, we use this word, this common law damages, that is an order of the court that says the other side must pay you a sum of money, a fixed sum of money. Again, putting our accounting hats on, kind of annoyingly, interest on what we call these judgments, these court orders, interest is calculated quite a high rate, but it's a flat rate. Now, that's again with our accounting hats on, that can be a little problematic, particularly if you've got an order, a court order. Court orders don't expire. You can go and ask them, look, if you wait for a really long time and then the person dies or leaves the jurisdiction, then it's not going to be any worth you. But in theory, they don't have a duration. Now, when you do have one of these things, if they don't pay within a certain length of time, you can actually also ask for interest, but it's calculated at a reasonably high flat rate. I think at the moment it's 6.5%. What does that mean? Well, if they don't pay you for a really, really long time, it doesn't compound. So, unlike other forms of debt, where if your interest rate's 5%, but it's compounding after 10 years, that's per annum is going to be way more than 6.5%. Yeah, court orders, you can get interest, but it doesn't compound. So just make note for that. And they also give, I think there's an interest-free period too. There's a court order and you have a certain amount of time to pay. Now, when you're doing, and you've got your little court order, you've gone to court, you've won, they've said, yes, the other side has to pay you, just procedurally. You've got a piece of paper, so what? What happens next? You actually have to have what's called an enforcement hearing, which is going back to court again, making the other side turn up, and they have to fill in a form that lists all of the assets that they have. If they don't do that, then you have to apply to the court to get some other form of order, either what's called a garnishee order, which is to either ask a bailiff to come in, pick their stuff up and take it away so you can sell it, or to ask the court to go to call their bank up or their employer up and say, can you take a fraction out of their wages? This is one of those real problems, and that you guys as business students probably appreciate much more. Deep pockets theory. There's no point suing people with no money. Centrelink, for example, has protected amounts. So people can't have more than, I think, 20% of their wages garnished. So if somebody else, some scallywag owes you money, and they're already paying off somebody else by garnishing a fraction of their Centrelink payments, you ain't going to get money from them. It's like, they can, but it's a small amount. It's not. Sorry, it's probably not 20%. It's protected. You can. Usually, what they try and do is, that's right. They can. I have seen it. I have seen it happen. What you find though is that rather than garnishing things, they try to get people to enter into debt agreements rather than send them bankrupt. People have this fear of bankruptcy, but if you're in a situation where you've got a lot of particularly personal finance debt at very high rates, I've advised multiple clients to go and just don't enter into those arrangements, become bankrupt instead, because after 3 years, you're in a much better position to start again. Unfortunately, I did it for long enough to actually see people go through that and come out the other end, and then, oh, they've got a brand new cell phone, and they've got a brand new this, and you're like, oh. Yeah. But they can actually garnish. There is, I'm pretty sure, because I remember doing it, getting Centrelink things to it, but it's only a finite amount. It's not more than, I think, 20. It's not 20. It might not be 20%. I can't remember the exact amount, but it can be done. Look, to be honest, if you're in a sort of business that requires you to actually get a garnishee order to collect money from people that are on welfare, something might be wrong in your business model, because it's just a whole world of misery that you're creating as a result. There's some certain rental companies, I won't name names, but I don't know how they make any money, because they're trying to squeeze blood out of a scone by getting money from low-income people. But anyway, all right. So I mentioned earlier that there is this equity can provide remedies, and I use this phrase where common law damages are inadequate. And I'll talk about that at the end of specific performance. For example, buying things like land. Okay, so there are some, they're pretty rare, and we'll talk about them, I think, in about half an hour's time. The next slide is the most important slide in this entire subject. In my personal opinion, the most important case, one that I'm horrified when I talk to final year law students or grads that they don't remember. This principle from the mid-1800s is probably the most important rule that I want you to tuck away in your heads, because this is the basis of how damages, dollars are awarded for breach of contract. And it goes like this. It's so important, and it's not intuitive. If you talk to lay people who've not studied law, what happens when they breach contracts? I was gonna like sell this guy my truck for like 10 grand, but then I could sell it for this guy for 12, so I did that anyway. And so this guy wants to like sue me. I'm like, oh, no, I didn't take his money. No, that's not how it works. This is my terrible, was that Kiwi accent? I don't even know. Sorry. Poker Australia, that's it, yeah. I say bro far too much. And that it goes like this. You are not, and this is a fundamental rule, putting people back to where they were. All right? In contract law, you are kind of still compensating them, but you're compensating for the loss of the bargain. When they entered into a contract, they had their particular reasons for doing it, and you had your reasons for doing it. If you choose not to do it, not to live up to your side of the bargain, you must put the other side in the position that they would have been in if you did what you said you were going to do. All right? That is the starting point with damages of contract law. If I'm buying 100 boxes of ice creams off Jackie, all right, and she doesn't deliver them, all right, and I was going to sell those ice creams to one of the cruise ships for 10 times what I was paying for them, what's the position I would have been in? 10 times that amount. And so you might think it quite horrifying when you get sued, not for the ice creams that, I've paid for whatever it is, 10,000. I paid $1,000 for ice creams, and I'm suing you for $10,000. I'm like, what? It was only $1,000 worth of ice creams. Yeah, but I would have sold them to that cruise ship. All right, that is the starting point for damages in contract law. Those numbers can get out of control really fast. And we think about the world that we live in with lots of supply chains and that buying and selling of things. You being early in the supply chain, breaching your obligations to supply, means that the people further down the chain, the position they would have been in is to sell things for more. That is why this rule and this slide, I think personally, is the most important for the whole subject. It is one that lay people don't get. It's only through studying law this particular rule, which seems at first really unintuitive. The more you do learn about it, you're like, oh yeah, it kind of does make sense actually. But it's really important to know. It's the principle in Robinson and Harmon. That's just what the rule's called. All right, and so there's some things we've got to talk about because it's that very, very harsh rule is mitigated in a whole variety of ways. But the first thing you need to know though is like, okay, sure, the other side's breached the contract. There are going to be some situations where we can calculate this amount. I would have sold these to that cruise ship and it would have been this amount of money. Sometimes though you can't make that calculation. All right, and so that's really where these things come up. McRae and Amman Aviation, two cases. Now McRae I actually talked about, I think last week. McRae was the salvaging of an oiler that had sunk in the Coral Sea, and there was no reef. But the thing was, there was no reef, there was no boat. The records of the boat were wrong. How do you calculate how much oil you would have got out of a boat that never existed? Can't really do that very well. And so what the courts say there is that in that situation, you can't sue for what you would have expected to gain. It's just logically impossible. You can only sue for what you've relied on in terms of the other side, what was reliance damages to compensate you. And again, we can't put you in the position that, strictly speaking, that you would have been because we can't calculate that. So we're going to go on the basis of what you have actually outlaid. And do the things that we can actually calculate. And that is going to be, in that situation, putting you, most situations, back to where you were. If you can calculate it, and again, Commonwealth and Amman Aviation was a, guys had a bunch of charter planes or helicopters, I think it was, where they had basically expected the Commonwealth, had given them a few contracts, to give them a whole bunch more contracts afterwards. So as a result, oh hey, we need to spend like, $2 million here, but if we spend a couple more $1 million, we'll be able to fulfill these contracts that the Commonwealth are probably going to give us because there's no one else here to do it. We reasonably expect that we're going to get these contracts. So they did spend all that money, and the courts went and analysed that because the Commonwealth turned around and went, no, we don't want to do these contracts. And so they said, oh, well, we've already spent all this money, reasonably relying on to get the subsequent contracts. And there the court said, well, look, you actually probably can calculate the amount that you were expected to get. It was that 91i in Mason Court, of course it was. And so look, these things come down to what can be calculated. And again, you guys as accountants, you may be involved in having to analyze these sorts of things. Actually get your economists, get your actuaries, work out what it is that we would have got from this particular contract. All right, and also note for things where there is a chance, a percentage chance, the courts will often just go, okay, sure, there was a percentage chance, and Howe and Teefy and Chaplin Hicks were both, one was a horse racing and one was a beauty contest. So Chaplin Hicks, I think, was the beauty contest where there was a prize, £1,000. There were 10 entrants. I'm fudging those numbers. That's not exactly what I know, but assuming that it was 10 entrants for £1,000, and you would have been the 10th entrant, but they've made an error. They were in breach, clearly in breach. You did the application. You submitted your application first, so you would have been one of those 10 people. How much are you likely to get from the court? What's the salient amount that the court would award you? 10%, 100 to £100, and that's what they did in that situation. Look, we can't calculate whether you were more beautiful or less beautiful than the other candidates. We're not going to do that. We're not in a position to do that. But we can just divide the percentage chance and just consider everyone to be even. But there are other situations where if your if your horse or your greyhound was likely or not likely, the courts are not good at judging those sorts of percentages. You have to bring the evidence to the court to try and prove one or the other. And look, they're very reluctant to do it. They're happy to do it flat rate, fixed percentage, but not if you're trying to argue that you are somehow better than all of the other sporting teams. All right. That is the compensation principle. All right. There are three things that I'll talk about now, which is to do really the three ways that limit damage awards. So this example with Jackie and these ice creams, all right, there's three ways that Jackie can either remove or either reduce the amount that she has to pay or completely absolve herself. The first one, the most important one, and the one in my experience, in my relatively limited actual legal practice experience, the one that comes up the most because it's the hardest to prove, is causation. You as the person bringing the action, me for breach of contract, she didn't deliver these ice creams, is I have to prove that Jackie caused my loss. That's hard. That can be hard to do. And the test in contract law is usually a little bit more simple. When we do tort in about 3 or 4 weeks' time, they have much more complex tests of what they call tests of causation. But just make note, the plaintiff must prove that if this harm wouldn't have been suffered, so this loss, in my case, the loss of all of this profit, wouldn't have come about, Jackie did what she said she was going to do. All right? It's what we call the but-for test. It's a very simple test of causation. I, as the plaintiff, must prove that I would not have suffered this harm but for the breach. And this is mitigated by the courts by a test of common sense. So here, for example, I might be able to prove that I could have on-sold these things to this particular cruise ship. All right? I might have been able to take ice creams and sell them to the cruise ship, and I might have sold all of them. But for $10 each? Really? $10 each with a cruise ship while it's parked in port? The courts might look at that and say, no, it doesn't. There's no world that we're living in where that's going to actually logically function. They temper these things. And look, in practice, this is the hardest thing, both in contract and in tort, is proving causation. You have to prove that the harm wouldn't have come through. And this can be really hard if there's multiple factors here. For example, what's an example? The cruise ship might be late, or might have been late, or the cruise ship was only half full. Cruise ship, or there'd been a what they call a plague, flu or something had been on through it as it had crossed through Cairns. A whole bunch of people had got out and then flown down. Yeah, that's it. It was under quarantine. All sorts of other things can do this, and it makes causation hard. Causation is a hard thing to go and prove in those situations. So that's the first thing. And me as the plaintiff, I need to prove this. And if I can't prove on balance of probabilities that this particular harm, which is the loss of profit that I've had on all these ice creams, wasn't caused but for Jackie's breach, I don't get anything. Not that it's reduced, I got nothing. It's a mechanical step the plaintiff needs to actually prove in order to get any dollar awards, other than a nominal amount. Again, contract law, you can always get a nominal amount. Here's $100. Yes, she didn't sell the ice creams. Here's $100, go away. That's what the courts will tell me, because I couldn't prove the actual amount of harm. I can't quantify it. That's the first thing. Second thing is what's called this test of remoteness. All right, test of remoteness says that we will not award damages to a party if the particular loss was so far removed, so many steps removed from the actual breach itself. All right, if it's way, way, way too many steps removed, we're not going to award damages here. This is what's known as the test, or the rule in Hadley and Baxendale. That involved a mill, and the mill had a crankshaft that needed repairing. So a fundamental part of the mill itself, all right? And it went off. Yeah, I think I might do this. Oh, yeah, thank you. The mill went off, and it went to the repairer, all right? And the repairer, there was some delay in transit. All right, so this mill, big flour mill, there's a delay in the repairs and the transit, and with the courier, and so the operators of the mill went to sue, and they argued, look, this mill's now been out of operation for 12 days. Okay. All right. So they've got the crankshaft, given it to the transporters. It's gone back, and it's taken ages to come back. And so they wanted to sue because it was longer than what was expected in the contract. And when the thing came back, the transport operator, the people that picked the thing up and took it away, were horrified to find they didn't have a spare crankshaft. So the whole mill was out of operation while this repair to the crankshaft was happening. So the fact that it was a few days late was that sort of moment of horror. And just imagine if that was your business. Oh no, this massive big mill didn't have a backup. That seems crazy. And so they're the courts, they mapped out this rule and said, look, things are going to be considered not too remote. And this unfortunately is tricky to get your head around. If it's either something that would arise as a naturally occurring consequence from the breach itself, natural and reasonably occurring consequence of the breach itself, or it's something that we might have reasonably contemplated at the time of formation. Not that we actually talked about it, it's a lower bar than that. If we did actually talk about it at the time, it's clearly not going to be too remote. We talked about it. Even if it's not a term of the contract, we talked about the fact, jokingly having a few beers after we signed the contract, oh yeah, like that, better hurry back because I've only got one crankshaft and my mill can't run until you get back. If we actually did it, that's fine. But it's not even that, it's a lower bar than that. Is it something that we might reasonably have contemplated at the time of the breach, as the result of the breach, at the time of formation? All right, those are what's called the two limbs of Hadley and Baxendale. And this is quite hard to get your head around because it's tricky. This is actually quite a tricky rule. So things, in order to determine whether this chain of causation to some harm that happened through a whole series of events later on is too far removed, we have to apply this test. Is it something that occurred naturally as a probable or reasonable consequence of the breach, or is it something we might have contemplated at the time of formation? If either of those things are true, then the plaintiff can tick that box. It's not going to be too remote. They're going to be able to seek some form of compensation for that breach of contract. All right, that's the second of the two damage limitation aspects that we have to talk about quickly. Sadly. The third one is mitigation. Now, when one side is in breach, all right, one side's in breach, and the other side recognizes this, all right, for example, with the ice creams, all right, let's just say we'll flip this around. And Jackie, I'm buying the ice creams. Oh, no, I'm buying the ice creams. That's right. But when Jackie comes to drop them off, I'm like, oh, sorry, I can't do this anymore. Sorry. Yeah, no, the boat never came in. I don't want to do this contract. I'm in breach because I'm not going to pay. All right. Jackie actually owes me a duty. And this sounds a little unintuitive. At that particular point in time, oh, sorry, silly pictures of cats. At that particular point in time, she owes me a duty to mitigate my loss. And it seems a little unintuitive why that would be. And look, again, if we go back to the courts of ye old England, they didn't want people rocking up with containers of ice creams, dumping them on the strand and say, you're going to owe me all this money, and walking away. That's really inefficient. All right. So what they say is that, look, Jackie from this point has to take reasonable steps to mitigate the loss. All right? And the courts say if you don't do that, avoidable loss, that can't be recovered. What are some reasonable steps? If you're on the strand with 10,000 ice creams, you're about to deliver them, what are some reasonable steps that you could take? Yeah, just go and sell them to somebody else. In fact, you get these stories of scammers. In fact, that's example of scammers that pretend that their ice cream truck's broken and then wander around, oh, we've got to sell these ice creams because the truck's broken, so people buy lots of ice creams. Turns out they were just trying to sell lots of ice creams at a cheaper rate, and that's fine. And that's what it is. But basically that's what it is. You actually have a positive duty to do that. Avoidable loss you can't cover for. You actually can't be compensated for. And to kind of make it kind of twist the knife here too, loss that is actually avoided, you can't recover for that either. So the situation here might be, for example, I'm trying to think of the cruise ship. If instead of you going and delivering them to me, you went and delivered them to the person I was supposed to give them to on the ship, for example, or like that, or you stored them overnight and gave them a day later. Curiously, if your loss gets avoided in that way, then you can't claim for that. So you've got avoidable loss that you can't claim. So you must take reasonable steps. And if you don't take reasonable steps, all right, the loss that's avoidable you can't claim. But if you did manage to avoid the loss, say for example, I can't buy the ice creams, so you go, and it turns out you call up one of your other suppliers and they're like, yep, we'll buy them at that exact price. All right, by the way it works, you can't claim for that amount either. That makes sense, because where's your loss? There. Now, there is actually another little rule involving that, because strictly speaking, you could have called both of the two of them up. But assuming that you're the person that you've called up, for example, now that these guys can't complete the contract, you can make this additional sale. Because if you could have made 2 sales, you can still sue these guys, because you've just lost 1 complete sale. Again, this bit's tricky to get your heads around as well. If we think about it, if you're selling ice creams, and you could have sold an unlimited quantity of ice creams, because you call up your supplier and just get more. If you can't sell to me and you can sell to somebody else, well, what was stopping you selling to me and someone else? Nothing in that situation. It's only if these guys will only take the ice cream so they can supply the same cruise ship. All right. So in other words, you're not losing a sale as such. If these guys wouldn't have bought those same ice creams, if this one didn't happen. There's a tricky thing to get your head around, actually. This idea that it has to actually be a lost, a sale that you wouldn't otherwise have got in order for you to do that. Because what are you losing by me not living up to my side of the bargain? A sale. You've lost a sale. You've lost the profit that you would have made on selling those ice creams. All right. If you could have made 2 sales, well, and now you're only making 1, well, you've lost 1 sale. You can still sue me for that amount. The fact that you've gone and sold the exact same batch to someone else that you could have sold any old batch to, that's fine. If, however, these other guys are only buying it as a result of me not being able to complete the contract, you could never have made that sale in the first place. It only came up as a result of my breach. Therefore, that's what's called avoided loss. And you can't sue me. You can still sue me. I have breached. You still get nominal damages, $100. But strictly speaking, it's avoided loss. And that sounds kind of curious, even though I've done the wrong thing. And you've managed to, taking your reasonable steps. Oh, well, look, I've managed to sell them for the same amount. But that's pretty rare that comes up. That's pretty rare. Usually there is a loss of some sort. And you take reasonable steps. We're selling your ice creams for 50 cents each on the Strand. Here you go, ice cream 50 cents. Ice cream 50 cents. And then suing me for the difference. All right. And there's a couple of specific situations which I'm going to talk about here. Specific types of contractual damages. This is a rule that can come up. It can come up for you guys, and if you're involved in contractual negotiations, you'll need to know what the term means. Basically, when you're negotiating a contract, we can say, oh, look, if you breach by not accepting my ice creams, you're going to have to pay me $1,000, for example. $1,000. We can put whatever number we like in the contract. It's a contract. All right? If I rock up, I reserve the right to take the ice creams away and sue you for $1,000 for restocker's fee or whatever. Now, what we call those things in contract law is a liquidated damages clause. It is a pre-estimated damages clause. Why would you have these? So we don't have to calculate using all of those rules of course, the principle of Robinson-Harmon. We don't have to use the expectation and reliance damages. We don't have to calculate these things if we've already enshrined the results of breach into our contract ourselves. Courts are really happy for people to sort their things out themselves. And so they're happy to have genuine, pre-estimated damages clauses in contracts. It's an excellent way of mapping out in advance what's going to happen when things go wrong. Okay? And you guys would have probably seen these sorts of things. If you don't meet this payment, meet this part of the contract by this point in time, you're going to have to pay this amount of money. Now, key thing that the courts have been very, very, very hard on for a long time is that there's a big difference between a pre-estimated or a liquidated pre-estimated damages or a liquidated damages clause, where we're estimating the damage for breach in advance. Big difference between that and a penalty clause. A penalty clause is an amount that a breaching side has to pay, put into a contract, that is fundamentally designed to terrify one side into doing their side of the bargain. That is the sole purpose of it. It's designed to tyrannize, is that the amount that I used over there? Terrorize the other side into living up to their side of the bargain. So with the ice cream example, if for whatever reason I'd put, no, you're the seller, you've probably got more power here. You'd put into the contract, if you don't turn up and accept my ice creams, you're going to have to pay me $100,000 for this $1,500 contract. Clearly, that's out of whack. There's something, and to be honest, that's the sort of thing you would think that me as a rational individual would never enter into a contract like that, but people do. People enter into those things, and you'll notice, maybe you guys might, but the older of you amongst you may remember back in the day, going back like 20 or 30 years, Telstra and Ergon, all of these utilities companies would put penalty amounts into their contracts. Does anybody remember seeing anything like that? If you don't pay by this amount of time, we're going to penalize you this amount. Does this sound familiar? No. Well, the way they do it is say that you get a discount by paying by a certain amount. This is the actual amount that you were always supposed to pay as part of the contract. So that is a key distinction between those two things, because if you are putting clauses into it, people can challenge them as being unreasonable. And that is what the banks about 5 years ago suffered. They failed and had to refund a whole bunch of people because the clauses they put in, you can put clauses that say, if you're in breach, we need to charge this much money, restocker's fee or handling fee or administrative fee, but the amount has to be reasonable. What does that mean? It means that if it goes to court and class actions where many thousands of people go together, get one person to represent them all, go to court, and they did, to argue about bank fees. And so the banks then had to try to argue that what the clause they had there was reasonable, and they failed. And the court said, no, you've got no mechanism for calculating this. Banks have been through a little bit of scrutiny over the last wee while, but that's essentially what happened. Justice? Good.
Does it matter who introduced the clause, the equality clause?
It does matter. Yeah, the powerful party. Usually, in situations where the courts are trying to determine whether something is a genuine pre-estimated damage clause or a penalty clause, which can be struck out, they will look at the relative power of the parties and how the thing was drafted. So did one side draft it and put terms in and have a take it or leave it standard form? So again, negotiating with Jetstar, we can't. But for where things are a bit more even, and you may find this in terms of business as well, where you've got some businesses you're dealing with maybe more even in terms of the power dynamics, that's harder. It's harder for the courts to try and determine whether this is a penalty clause or not. Because in theory, if the two parties are even going into a contract, all right, then the power dynamic means that they can either accept or not accept these pre-estimated amounts in the contracts or not. We can turn around and just say, no, we don't want to enter the contract.
I've seen one about property.
Hmm?
So one offers to buy property from the
Yep.
And the buying party introduced the penalty clause. I'm not sure you can categorize it.
Sure.
They say whoever breaches
Yep.
will pay a third of the property
Yeah, some fraction of those things. Yep.
to the other party, but then he defaulted. So
Yep.
how does that end up?
Yeah, I will often, by default, that is going to be valid. Now, often you find with residential tenancies, residential property, it's often in the form of deposits, which, just as it happens, is actually the next slide, because it's not uncommon for deposits to be the thing which gets fought over, that amount. Now, what you can do in terms of commercial property, though, is for things like time. If this thing doesn't happen, or developments don't happen by a certain length of time, you're absolutely, completely able to put in clauses to say this amount is payable. And companies do that. They do this all the time. That is, they are real, they are genuine, and provided that they are reasonable and not fundamentally designed to scare one side, usually the weaker side, into performing, then they're going to be held reasonable. And the courts, when doing and granting awards, will look at that. And the reason for that is that, strictly speaking, it's a term of the contract. And we want to go through and look at what the parties, objectively speaking, agreed to at the time. And said that, look, when I enter this contract, this needs to be done by this time. And if it's not, this amount becomes payable. If the two parties are coming to this on an even keel, this amount, is something that both sides were, in theory, happy with. Where it's a problem is where there's an imbalance of power, and the courts do go through and look at that. And so this one here, again, when we're looking at things like deposits, equity can also intervene there as well, but they look at these things in terms of deposits, the fraction or the amount which is paid. Because usually with a deposit, when you go to buy a house, before you do the settlement to actually convey the house, you pay a deposit, you pay a certain amount of money, and if you don't go through with the contract, you'll lose that money. That is something that you have done to demonstrate a clear willingness to enter that, and that forms part of it. And so the courts, generally, that's fine, but again, the amount matters. So 10% has been classically the amounts that the courts were happy to accept and say, yeah, okay, 10% of a contract in terms of the one side breaching and wanting to get out, not wanting to go through with a property transaction, that's fine. When it enters more than that, when it gets sort of 18%, the courts are happy to look at it and say, well, that does seem like a lot. That seems like an amount that fundamentally isn't designed to just be a deposit, which is a demonstration by entering, giving money, that a party is willing to go and complete a contract. 20% of it actually sounds like a substantial amount, and that it's going to cause some form of injustice if that is used to be the pre-estimated damages clause.
Actually, the party who introduced the clause,
Yeah.
2% is the party who reported.
The party, oh really? Oh wow. So they put the clause in to say they're going to pay this sum of money if they would do it. Well, I mean, when I step back and look at it sort of objectively, you think, well, in that situation, from that perspective, that sounds like not good negotiating tactics. If they were the ones that wanted to put in a penalty clause for themselves, or was it a penalty clause to operate supposedly across both? If you don't perform and we don't perform at settlement, the one side has to pay this amount of money. That's unlucky, because in that situation, the courts are not going to strike it out as a penalty clause because it's not designed to tyrannize if both sides were happy with that, even if, as it happens, that it happens to work really badly for the person who put it in. That's interesting, actually. It's an interesting situation. That just sounds like bad luck. I don't think the courts would be happy to strike that out. Not here. Even if, look, they probably will if it's a very large amount. And again, going back to things with deposits, if it's a large amount as a fraction of the price itself, then they may be more willing to strike it out. But particularly, in that situation. But again, it depends what the fraction of the amount is to the total contract. I couldn't really say either way, but it's actually quite funny. I'm going to tuck that away. So the party wanting to put the clause in was the one that ended up defaulting. Okay, well, that just sounds like hard luck. I imagine on their part. I imagine they probably end up having to fight that. Just note there is also in situations where it's unconscionable to keep a deposit for the sale of land, equity can provide a remedy to do that. It very rarely does. So just be mindful that you have to prove that the particular situation is it has to be a large amount, and it has to be unconscionable for them to keep it. So the circumstances have to make it as such that it's not in good conscience for them to keep it. And again, it's pretty rare that that's going to happen. Most situations in residential tenancy, if you pay a deposit and then you don't settle, you're going to lose it. All right, we're almost done, guys. All right, some other things that'll reduce damage awards. Small rules, again, these are things that from today, the principle in Robinson and Harmon is the single most important thing you need to know. Everything else flows around that. I can't stress that enough, that idea of damages in contract law. The rest of these are little small rules that yeah, I'll talk about, but they don't come up that much. All right, first thing to note, you don't get damages in contract law for hurt feelings. Contract law is not about feelings. It's about two parties coming together, exchanging promises. We don't care. Contract law, the courts of Ye Olde England don't care about your feelings. They also don't care usually about your disappointment, discomfort, or distress. However, there is one exception to that, and that is if, everyone know what that might be? One time where you can get compensated for discomfort, disappointment, or stress is when, well, it's when the purpose of the contract was to provide you with comfort, a holiday, or to de-stress you, and the breach actually caused you to be more stressed. So the example there, Baltic Shipping in Dillon, was a boat, a cruise ship that actually sank in Marlborough Sound in New Zealand, and Mrs. Dillon wanted to recover the purchase price, and because she wasn't happy about the whole thing, the court said, look, this is actually a corner case. It doesn't happen very often. Normally you can't sue for disappointment, damage, and distress, but here the whole fundamental point of the contract was to have a cool holiday, and she came out not having a cool holiday because the boat sank, and so there she did get a damage award in that case. Very similarly, normally you don't get damages in contract law for the loss of reputation for your business. What would one exception to that be, do you think? When no, there's no damage. We don't care about it. It's nothing to do with defamation in this case. The one situation where you will get damages for a loss of reputation to yourself or to business is when the purpose of the contract was to enhance your reputation or branding for your business. So again, marketing companies. If you're a marketing company and you have you do a branding campaign and you use Nazis in it, and the company ends up suing you because now their brand is worthless. I mean, we as accountants think, well, clearly we can think of brands as being something that's valuable, but also personal reputation as well. That can come up too. All right. One thing to note, and this can come up, is that if you went back 20 years, the laws of contract changed in Australia. This is driven, by the way, by insurance companies. The Civil Liabilities Act has essentially been written by the insurance industry to try and reduce the amount of dollar awards, because they started getting crazy in the 90s, like $5 million for personal injury awards and stuff. They were going the path of the Americans, and one of the insurance companies, HIH, actually went broke. And so all of the states and territories came together with Commonwealth government, mapped this out, and they created the Civil Liabilities Act to try and mitigate these things. One of the things they did pass, though, it was in the late 90s, was in some situations, remember before I talked about the principle in Robinson and Harmon, purpose of contract law is to put you in a situation where you would have been in, but for the breach. What if you have contracted with a surgeon and you're an athlete, all right, and the surgeon stuffs it up? All right, now you've got this quirky situation here that operated until I think 1999 has changed, where the surgeon, if the surgeon is being sued, they are sued in terms of personal injury for being negligent, and we'll talk about this in a couple of weeks' time. to put the person back in the situation they would have been in, all right? To compensate them, to get them back to where they were. Pay all your medical bills, pay for your loss of income and stuff, and that's it. Right? But in contract law, is that the principle? No. Principle Robinson-Harman puts you in the situation you would have been in. I was an athlete. I can prove that I was going to get this contract, or percentage chance of getting this contract with the, with the Cowboys, and I would have earned this much money. So you had this weird situation where suing in contract law, in terms of for things where there was a coexisting duty and negligence, suing a contract would get a lot more dollars. This actually happened to a client of mine. Curiously, the date of the two is different. With contract, it's the date of breach, and in tort, it's the date of harm. What that means for my client is that the date of breach was over 6 years ago. So she couldn't sue in contract. She could only sue in tort for professional negligence in that case. Sometimes the two exist, the two duties coexist. This will make more sense when we study tort. But just make note that Parliament has come in and said, in situations where this happens, it's actually the lower of the two. Insurance companies stepped in, and so you can't get damages in contracts. Essentially, you get the same amount as you would get in tort, which is lower in most situations, where there is a coexisting duty in negligence and in tort. And again, this comes with things like professional services, professional advice for all those wanting to be accountants out on your own. Hooray! That's the situation. That is the quantum of damages for those sorts of things. Statutory mechanism. Okay, and so just make note that as a result of doing this, you get, when these things coexist, you can have contributory negligence. All right, and again, this didn't used to be a thing till they changed the law in 1999. What that means is that if there's a coexisting duty between the two, in contract law by default, it doesn't matter that I was slightly at fault. It doesn't matter if Jackie can't deliver these ice creams. The fact that I may have contributed to that by, I don't know, accidentally giving her the wrong address or something similar to like that, and then called her up and she delivered, and I told you to go and get from this particular supplier off in Melbourne, and they turned out to be useless. It doesn't matter that I somehow contributed to the harm in contract. It does matter in tort, and the damages are awarded separately. But thanks to Parliament, now the two are combined. So me actually adding to my misfortune, where there's a coexisting duty in tort, will actually mean that my damage award's reduced as well. Sorry about that, that's a little bit too much information. All right, I think, is that the last slide? Oh, is that the last slide? Okay. Just really quickly, we'll go over the last, I think there's a couple more. I'd mentioned about other things other than money. You can get things other than money in contract law. All right, and again, only when money is not going to be an appropriate remedy. You can get these equitable remedies. You can only get them through the court. You do not get them by right. They are discretionary. And the first one of these is what we call specific performance. Again, it's another legal technical term. Comes up in land. Specific performance, if you look at your Queensland Real Estate Institute standard form for sale of residential property, will have something in there, a clause in there to do with specific performance. That is when you make the other side go through with the transfer to you. Specific performance is when you make the other side do that. In almost all other situations, the courts will not let you do it. They'll just say, here's some money, go away. All right. The other situations, and this comes from Dugan and Lay, the third point down there, is where the particular subject matter is unique. Unique or scarce in some way. There it was to do with taxi licenses. Person bought a taxi business and wanted the license transferred as well. And there they said, in that situation, taxi license, you can't get them from anywhere else. They were finite. This is back in the day. This is pre-Uber, going back, was that 1950s, 40s? And so that is something the courts will say, in that situation, we can grant specific performance. It's an order from the court to make the other side do what they said they're going to do. Now that sounds a little bit weird. Making somebody do something, sounds like akin to slavery. So the courts don't do this in a whole variety of situations. First of all, they're not going to do it if it's going to cause some form of hardship to the other side, hardship and mounting some injustice. They're not going to do it when with dollars are going to do it, or there's some other form of remedy. They're never going to do it for personal service. You can never literally get the court to make somebody come and mow your lawns if they don't want to. You know, if they've entered into a contract, you just get money. All right, and also that last one, they're also not going to make people enforce contracts where the courts would have to supervise to make sure they're turning up, you know, to supervise, you know, a security company. If you get them to come and do security on a particular building, you're just going to award dollars in that situation. You're not going to make that security company come and turn up every day for 10 weeks because you'd have to go back and check, and that would be dumb. The courts aren't going to do a contract that's going to require supervision. All right. Another thing, another form of remedy that you can get can come up in situations where the other side looks like they're going to keep breaching, and you're going to suffer some form of injustice if they're going to keep breaching, and money's not going to help it. Here, and we call that an injunction. Injunctions are only awarded in equity, and it's a situation where usually we're going to ask the court to prevent someone from doing something. We are going to prevent them from broadcasting this. So we've come together to create two parties have come together to have a contract to create a movie of some sort, or a TV show, and the TV show, go and produce it, and it's going to reach this point where the other side's like, oh no, we're just going to have this. Yeah, we're in breach. That's fine. We're just going to take this and broadcast it. You, in a situation where it's going to make you look bad and hurt your reputation, you might be able to ask the court to actually grant an injunction stopping them from doing it in a situation that it may cause some grave injustice on you, your reputation. Remember, you can't usually sue for reputation in contract law. Usually don't calculate it. There are some corner cases where an injunction might be required to stop this grave injustice. It's pretty rare. And again, they don't use this where specific performance is the appropriate order to be granted anyway. All right, I think that's a short time. Okay, before I think I talked about situations where one side might end up with the other side's money, but there is no contract. Remember, a common mistake? Oh no, what do we do? Okay, I've paid some sum of money, but it turns out the subject matter, neither of our knowledge, was destroyed before the time of formation. All right, common mistake. We're both equally mistaken about the subject, but I've transferred the money. So Gene, with this boat, I've given Gene the $10,000, but the boat had been destroyed through neither fault of ours and to neither of our knowledge before we formed the contract. At this point, what happens there? Well, strictly speaking, it's my money. I would like it back. Now, there, we can also argue there's been what's called a total failure of consideration. I got absolutely nothing out of this contract. Therefore, as a result, the courts can grant this order in equity for this money to be directly given back to me. Now, how does this work in situations where a contract can be divided? Going back to the 5 rooms in the house, or if 3 of them have been done, 1 of them was done half-assed, and the 5th wasn't done at all, well, the courts can just divide that up and say the 4th was a total failure of consideration. That $1,000 that was paid, it belongs back to me. All right, and that's an order that the court can grant, or the grant of restitution, falls under the area of equity. So just, I think it's the last slide. Okay, occasionally this will come up. All right, in situations where work has been done under a contract that both sides usually thought that was a contract, or a contract was going to come into existence, but for whatever reason it doesn't. And this is kind of similar to that Sumter and Hedges rule, but it operates a little bit differently. Sumpter and Hedges, remember, if the other side voluntarily accepts work that's been done, the very, very first slide of this lecture, early slide, voluntary accepts. But in situations where the other side hasn't voluntarily accepted, the other party's nonetheless done work thinking that there was a contract. Right? Both sides thought that there was a contract. Work's been done. Somebody's gained a benefit. The innocent side here, it turns out there wasn't a contract, can still sue for some fraction of that under what we call quantum merit. And again, it's under equity. And it's discretionary. You have to ask the court to grant it. You can't just call them up and say, oh, I did all that work for you. You know, I spent all this time and money. I want to be paid. No. You have to get the court to do that. So if a person calls you up and says, this has happened, you are not obliged to pay them until they have got an order from the court, because it's in equity. It's not a common law. That's all I've got. I'm sorry that this was a lot for your head. I'm sorry about this. This stuff is it's one of the harder lectures to go through. There's lots of little rules. Some of them require thinking about particular sets and circumstances. I hope the ones that we've talked about have been useful. But fundamentally, breach of contract always gets money, and the principle in Robinson and Harmon always get to be put back in the situation you would have been in. That difference can be massive. And that's all I've got. But
I mean, I just thought of this thing that happened. Some of my friends from Brazil had gone to purchase papyrus from Egypt.
Papyrus. Oh, yeah, sure. Yeah.
And they wrote something in Egyptian and told that that's their name. I mean, these people did not know what it was.
Sure.
That person just like randomly wrote something in Egyptian and they said, it's your name.
Yeah.
He's like, oh, okay. And then they were like, you have to pay for it.
Oh, yeah, no, that's a scam. That's I've heard there's all sorts of scams like that. Oh, you just step this way. We'll just take your bags over here, and you walk. Yeah, you guys fine. When you go into countries where you look like an outsider and you look like you have money, come on, we've seen this everywhere. Like this is how. I think all of us have had that. And no, well, the thing is, you're never going to be able to enforce things like that in contract in those places anyway. What are you going to do? We don't know. We don't know where would we go? Who would we complain to? We've got no idea. There's no mechanism. That's why when you're in foreign countries and you're dealing with their legal system, you always want to be on your feet all the time. I find that the first thing I learn is usually the local word for politely, or whatever the local word is for no thank you. No thank you in relation to everything. But yeah, that's quite funny actually writing on the papyrus ahead of time. Yeah, nothing to get up on that. But we've got no way of dealing with those things.
I just wanted to ask about our assessment.
Oh yeah, yep.
So we have an online quiz
Yep.
next Friday.
It's Friday after, I think. It's Friday after. I think it's Friday after. Was it Thursday? Yeah. What do you guys want me to do with that? Do you want me to move it off Good Friday and just put it back a week? It's up to you. It's completely up to you guys. Back a week. So the 26th? Or do you want? No, I was thinking later. Usually those. I'll never push them earlier. Later. It's up to you guys. What do you want? Do you want me to move it back a day? I can do it one day. It's probably fine on the Thursday. Or what do you guys? What do you guys want? I'm not really sure on those things. I don't know. Does the public holiday? Because I don't know if you guys, particularly for those that are recent in Australia, Good Fridays, it's public holiday, but a lot of stuff's closed. So it can be difficult to get around in terms of infrastructure if you want to go to the pub or anything to do your test. The labs are still open here, though, aren't they? I think they still are. Labs, because the labs are 24 hours. But do you guys want me to move that off the public holiday? Is that a thing? Because I'll put it to the vote. Does anybody here want to move it off? Anybody? Or does it not really bother people? Is it problematic that day?
Is it a Friday or Thursday?
On the. Oh, okay, yeah, sure, we can do that. So yeah, cool. That's I can do that. So do you want me to move it to is the Saturday, like, is it 26th? Do you want me to put it back to the 26th? I'm perfectly happy to do that. Yeah, is that all right? Is that? Yeah, no, it's like you just negotiate with the lecturer. It's just like, and next we don't want to be doing an exam, so like, yeah. Yep. Yeah.
I know that
Yeah, that'll do the pass bar. I haven't got them on there. Yeah. Oh. The satisfactory. I didn't do that at this stage. Not all of them will have to come back. All of the ones that I've seen. I'm not going to name names and stuff like that. So they're not quite at that stage yet. They're pretty close. The ones that I did say were pretty close. So they will come back. I'll have to talk about it next week, I think, in terms of the recording. But yeah, they're not quite there in terms of the quality. Just in terms of the biggest problem, I said one of them was pretty close, was in terms of sections and section numbers. The point of that exercise was to be stat interpretation, and I wanted people to actually go through and find the appropriate sections in the legislation. And so some of them just needed a little bit, not much more. It wasn't much more at all. Yep. Yeah, you can do that. With those, redo them and then send them back to me. Because we've skipped, remember that we've skipped one. So we can, I'm perfectly happy if you guys do want to send the things back, and I can just give you some more feedback again. You can turn it into an iterative thing. It really doesn't bother me at all. To reach up that level of quality to do that. It's 26 okay? Okay. All right, sounds good. 26, I'll just make a note. Oh, did yours, was yours with the one? What was your last name? Because I looked at it. What I'll do, I probably won't do it here because I just don't like this one. Is it Al or Il?
Yes.
So it's close. I don't know. I probably didn't spell it perfectly right, but what I'll do.
Islam, not that one.
Not this one. I'll just take that out. I'll remember. That's the only one there. So you didn't get. I'll just make a note of that. So you didn't get a grade. It's possible that it's because there were some of them where the file was corrupt, and I'd emailed back, but I don't think you were one of them. Didn't get a grade. Okay, I'll have a little bit. Yeah, sure. Yeah, that's fine. I'll find it. It's was it in my? Did you email it to me, or did you put it in? Okay, I'll just have a look for Hannah. I'll just have a little look because I've got on my. It's actually this computer here, so I'll just quickly have a look. Just bear with me. One for Hannah. Oh no, it's not on the list. Okay, well I'll have to. It must be lost in my email somewhere, so I'm gonna go through that. But sorry about that. I'll get it back to you. Or just while you're there, I'll just see if we can find it. We'll just see if we can find it here, and I'll save it, and then I'll get that to you. Sorry guys, I'll just let that rock and roll. Oh, I've got this thing tomorrow. Let's go. So is it for Hannah spelled like that? Oh, there we go. Was it? I'll check this one first. Good evening. Oh, you do have it there. Sorry about that. Good evening. Yeah, I've got that. I just haven't stored it in my I'll save that. Reflective piece. Oh yeah, it's. Oh, hang on. Oh, hang on. That's feed foot. Oh, no, I'm in the wrong folder. Oh, reflective piece is here. Assignments. No, I've got it in the wrong spot. Oh, I know why. No, I know why. It's because these ones I did through the Dropbox. That'll be why. So what I'll do, I'll have to just do a separate one. Sorry, I'm getting confused here because the other guys I got for the other task it was through Word doc. So I'll just put reflective. Yeah. And I'll just save it in there. I'll have to get onto that this week. Yeah, that explains why you're not getting it at all. Download that. Show and folder. Oops. Oh no.